started operation. And the Senator, thank you. And a number of our team members were not, well, we are online, so they're all online. From the ministry. I didn't get any apologies from any of the other technical team. There are a couple of things to do this morning as we go into the agenda before I discuss the actual report. Am I right, Ms. McCarthy? We had one outstanding point yesterday that we were to look at. Mr. Richard, you're able to clarify the issue of the reverse burden proof debate?
We did, Minister. We sent something back to the chambers yesterday.
That was, what number was it again?
It was clause 101.7.
Yes. So, Ms. Thompson, are we satisfied with the answers given?
Good afternoon, Chair and members. So yes, something was sent yesterday evening to the chambers, and we responded this morning with a question. CTD Richards had just responded right before the meeting. So we're actually just reading the response. But just to say that based on what we have read, the response, we don't think that. So if you can go to the definition of prohibited firearm, please. I think it's on page, okay, I have the yesterday's version of the bill. And in yesterday's version, it was page, still can't find it. Page 11.
That sounds like ASG.
Yes, yes, it is. Can you hear me?
Come on, thank you, ma'am. Good to have you. No.
Thanks. Yes, so I'm just saying on page 11, if you go to the definition of prohibited firearm,
right.
Paragraph F, so it says prohibited firearm means F, any firearm in respect of which no firearm authorization is granted under Part 5 or under the laws of another jurisdiction. Right. That's where the problem lies. So I asked, why do we have the words under the laws of another jurisdiction? Yes. The explanation that has been provided to me makes me think that it really should not have been in the definition. It should have been in a discrete clause. Putting it in the definition makes it have a very wide and general application, which was not the intent. And it has created the problem where you now are discussing having a reverse burden of proof. It really should have been in a discrete provision, because the explanation I got was that it is trying to address the situation where you may have, let's say, a visitor, a foreigner, right, who has come into the country, erroneously left the firearm in his suitcase, travels to Jamaica with the suitcase, and then you know what can happen. But my issues, the reason I got that response is because I asked CTD Richards the following. I said, and it's really coming from when you look at the provisions, all the offenses in Part 2 of the bill, really when you're trying to make out an offense, what you should be doing is looking at, give me a second, please, sorry. The elements of the offense. And what I couldn't understand is, are you saying then that if I have a registration or some sort of authorization from some state in America, that I wouldn't need an authorization in Jamaica? And I don't think that could have really been the intent.
No.
Exactly, but that is what has happened. Because I'm thinking what really should have been the intent is that you have a mechanism here that you could use your foreign registration as a factor in making your application for an authorization in Jamaica. It could be then that you have a different process. It could be a truncated process, whatever it is. But then in the application process, you would then display whatever authorization you may have had from a foreign jurisdiction to deal with the person, the visitor. There is a provision now in clause 33, 33.4, there is a provision that could address that situation. If the ministry thinks 33.4 is not adequate, then I would suggest you build it out.
Are you suggesting
Build it out. So you could flesh it out, you could make it what you need, make it what you want. But I don't agree with leaving those words in the definition, because it then would now apply to everywhere you see prohibited firearm, that definition will apply. And that cannot be the intent.
Yeah, I can see that quite clearly, SG. Thank you for that. Okay, so you're saying we could cover this kind of visitor in section 4 of 33.
Right, so I would suggest that perhaps there could be just another scrutiny on clause 33, just to make sure it captures the intent of the ministry. But I also recommend that those words about having an authorization in another jurisdiction, that those words be deleted from the definition of prohibited firearm. And then no, it would mean that you no longer need the reverse burden of proof. So you would delete clause 101 or part thereof, but I think actually the whole of 101.7.
All of 101 or 101.7?
101.7.
Yeah, all right.
I think it's the entire 101.7 that would be deleted. And just to say, I really wish, Chair, that I had looked more closely at the definition all along, because the mountain of research we went and did, really at the end of the day, the issue was really those few words in the definition, which escaped me at the time.
So in definition, with section F, prohibited firearm definition, F, remove the last part of after part 5 or under the laws of another jurisdiction.
Correct. Yes. So words or and everything after. Yes.
Okay.
Fully concurring, Chair. Fully concurring with SG. And I too missed or under the laws of another jurisdiction on the definitions.
On that basis, now we just must ensure that 33 will satisfy these individuals who come in with a firearm inadvertently and we don't need to lock them up for life, essentially. All right, let's see. That sounds pretty. And then you would have to remove the reverse. You would delete section 7 of 101. Minister, you're in-house lawyer today. No problem with that.
Chair.
Go ahead, SG.
If I could, no, this is Senator Golden Campbell, just to indicate the she's talking about in 33 in terms of the capture of somebody who would come in inadvertently. 33 does have a knowingly requirement, SG. So would that be captured?
Oh, so perhaps not. This is what I was saying. You'll recall that this provision was scrutinized by this committee, meaning there was some discussion about it. So I'm just suggesting, based on the explanation we just got a few minutes ago, that the ministry would then have to look back at this clause to see if it needs to be tweaked and make that submission. And I agree that looking back at it, I don't think it would address fully their intent.
Okay, yeah. So they still need to come back with some amendments to 33.
Well, good afternoon to everyone. Nadine Wilkins, LRD. I noticed that 33 speaks of trafficking though. The prohibited firearm isn't relevant only in the context of trafficking. It's much broader. Trafficking is specific. So, just wanted to point that out. Thank you.
I take the point, except I think the concept of trafficking is what is being captured, because trafficking is generally when you're moving it from, especially in the context of firearms and in the context of the convention, you're moving it from one jurisdiction to another. But I mean, it could be that you need a discrete provision. I'm open to all of that.
I actually think a discrete provision is more appropriate, Saljane. I think that would, to try to tweak an existing one may take us, send us unraveling other things, and it may delay us longer.
Okay, so we're going to look at some modification at 33 and not. Can you referring us to 36 as well?
Well, I was thinking that a discrete provision would be better, sir, because each provision dealing with specific aspects. Because for 36 is the declaration. Yes. Yes, actually, maybe. Maybe, because the declaration is a requirement, it's a first step. Yes, Chair. 36 can be looked at.
Okay. Let me know. So what are we saying finally on this? We're going to make minor amendments to 33. Not quite clear. 33 or 36.
36,
Yes,
Chair,
so
not 33.
So we're not hearing anyone from the conference room, sir.
36.
The audio is very low.
You hearing me now? I said what I'm getting from this is that we will make some amendments, minor amendment to 36. Just to be able to cover effectively the mischief we're looking to correct, which is the traveler coming into Jamaica with a firearm and inadvertently not declaring it, and is identified when he's going out. And we'll delete 1017. Okay, Ms. Grant? I'm trying to raise the volume a bit, but I'm going to stay close to the microphone, I'll show you. You're hearing me now?
Yes,
Yes, Minister, we're hearing
yeah,
you.
that's
Yeah, okay. All right, there was anything else for correction? SG, we have all clear to go to the minutes and the reports now?
Yes, that was all from me and
right.
from the chambers.
SG, when it's resolved for you, it's resolved for everybody.
I don't know about that. No. I can speak for Ms. Thompson, but I can't speak for anybody else.
No, we take your guidance.
Chair, just bear with me. I had an issue which I must confess was belatedly communicated to the CTD. I'm not sure that he has even had an opportunity to read the email.
Where is it? What you're saying, Ms. Wilkins? Where
it's in respect of the definition of 3D printed firearm.
Yes.
And the words at the end, where it says most produced or manufactured with a 3D printer or any type of electronic software.
Okay, the CD.
I'm saying the thing is, what you want to capture is what is produced or manufactured with a 3D printer or any other device that is capable of doing the same thing as a 3D printer. Not so much or any type of software, because the software is a different thing from the tangible implement itself that does the printing. So my concern was the or. So the software is used to produce and manufacture the printer. So if technologically other devices are invented capable of producing a firearm using software, I didn't think or should be at the end. I'm not sure how clearly I'm coming across.
I'm hearing you're quite clear.
No. Communicating the difficulty I have with that is mostly produced or manufactured with a 3D printer or any type of electric software. It equates the two when they're not the same. That is a concern I have. I think the issue is mostly produced or manufactured with a 3D printer or another device, any other device capable of producing or manufacturing a firearm using a computer program. I think that is the essence of what needs to be captured.
Bullet or other missile, and that is mostly produced or manufactured with a 3D printer. Why have or any other type of electronic software?
So it would be saying mostly produced or manufactured with a 3D printer, or mostly produced or manufactured with any type of electronic software. But it's not so much or any type of software that you want to capture. It's any other device that's capable of printing a firearm and using a computer program to do it. I'm not sure if
you're correct. Any other software is an odd way of saying it.
Yes. I just want us to.
You don't have the software is almost generic. If the software can manufacture 3D printer, then it's a software to manufacture 3D printer. You don't need what's important.
The implement that actually produces
does the manufacturing.
Yes. It's not the software that does it. It's not the software that does the manufacturing.
No, you need something that's future-proof, which is what I think they're looking at. But
This is it.
Or any other device that may be able to.
Well, we may not have the words today, but I'm just
sorry. Miss Grant has her hand up.
Yes, Miss Grant.
Oh,
please.
Yes, thank you. Yes, initially I had considered what Ms. Wilkins, the point she's raising, but then when I think about it closer, I'm not, when we speak about computer program, you're talking about electronic software. I don't think the reference to computer is technologically neutral. Also, it's not so much a device, I think, that you would want to capture, but it is the concept of the software. Because if you have machines that are capable of producing firearms, most of them, even if they're not 3D printers or 3D technology, any other machine that has some sort of electronic component would be considered an electronic device. So I think what you really want to capture is the concept of electronic software, because that is what provides the 3D aspect of it. I don't know if I'm making myself clear.
So then it would be that the electronic software is what is the thing, the implement uses to produce the firearm. So it's still not an or.
Why is it not an or?
Because then it wouldn't be would it still be a 3D printer? Would it still be a 3D printed firearm? Having regard to the point you had made, would it still be? If we're going as general and as broad as that. I was thinking that we were staying with the same type of concept of printer, but you're saying that it could be another type of machine doing, but would we regard that then as a 3D printed firearm? That's the only issue I would have. Yeah.
The original point was that we didn't want to limit it to the concept of a 3D printer since technology evolves. So we wanted to capture additional things as far as electronic technology would evolve. To capture those items, it might not necessarily be called 3G. Maybe later it might be 5G or 6G. But we just wanted to capture the notion that it is produced using electronic software.
Well, then I do have a difficulty with that, but I think the emphasis should be on that then, and not so much on the producer manufacturer.
In a sense, you both have elements of what, right? It's trying, I think, Ms. Grant is trying to future-proof this, which is right. The software would evolve over time very quickly, but you have to recognize it. But it might change. But it has to be a 3D printer because 3D is kind of generic to manufacturing, to manufacture like a barrel. You know, once you go beyond that, there's no four-dimensional object, not yet, in real term. So it's a three-dimensional object. So it would be, the printer may change in terms of its speed, type, etc., but it will be the same 3D printer to give you a three-dimensional object. The software also is what we'll have to ensure that when they change it from what they use now, they no longer define it as a, I can see that. You have to focus on the changing software. The printer itself remains, even if they use a different name, essentially a 3D printer. All right. So yes, satisfied, Ms. Wilkins?
Very well, Chair. Very well.
All right. Yeah.
Chair, if I might just to address the last point that Ms. Wilkins made, I don't know if there's any merit in just flipping the order in which they appear so that we could talk about any other type of electronic software, well, with any type of electronic software, and then say, for example, a 3D printer.
I said I sense difficulty, and I will have to be advised to word, because I can get the sense this can work, but I don't know if it could be interpreted in different ways, because I said the printer technically will always be a 3D printer. They can move just like a current printer move from those things, you know the old guest that was a printer to what we now have as the new HP printers, which print photographs and all kinds of things. It's still a printer. So I think, and initially my own concern as well, but it would be always a 3D printer because the equipment has to be a three-dimensional object they're printing. But the software can vary significantly to make it faster, to make it longer, to make it introduce innovations, which we can't even think of now in terms of getting the projectile out. So I'd work with that.
So, Chair, in the example I was giving, I didn't say, I said 4G or 5G, not B. So the point I was making that it might not necessarily be tied to the concept of 3D in terms of three-dimensional, but there could be a next generation type of technology that might be termed differently that would allow for the manufacture of a firearm.
The software is what would take care of that, because
right.
All they're doing is that, as I said, there's a different level of technology and they're moving now. There are several emerging changes that the speed 5G could introduce a different kind of software, but the output will have to be the same. It has to be a three-dimensional object. All right. I'll leave the legal. I'll be advised the legal mind. The technologists, people could take a look at it. If there's any tech-savvy person lying here, if there's anything else you could do. Okay.
Pardon me, Chair.
Is that Miss
Cunningham? Yes.
Yeah. Ms. Cunningham?
Good afternoon, everyone. Good afternoon, Chair. I just had a quick question. If we were moving on to the report or the minutes, there were several square brackets in the
Yes,
amendments.
yes, indeed.
So they're showing up in the report as well. So I was just wondering if we're going to deal with the square brackets now or as they come up in the report.
I better, Anila, we go through them. No, I don't think we'll catch them. I'm gonna go to the report page by page. That might be the easiest way. And then we take them as they come. All right?
Okay, I've got it.
All right. All right, should we take the minutes first, though? Can we approve the minutes before we proceed to the report? I will take them as read. We have been quite a batch of minutes. You all here, Nila? All the minutes. I think we have to approve all of them. Take them as read. Senator Charles, you have been at all the meetings, I think. You move for the adoption of the minutes.
And Mr. I'm not seeing Senator Charles right now.
Huh?
Seems as though he was kicked off. I'm not seeing him on.
And member Jackson, you also were, I think you came, no, you missed one or two, but. All right, the minutes of the, I'll go to them. The minutes of the March 9. Minister Williams, you're there. Any questions or can you move for adoption of that?
Yes, sir, I'm here.
All right, you move for the confirmation minutes of March 9.
March 9.
Seconded by Minister May. That's the very one, the first meeting.
Yes.
All right.
Yes, sir.
Okay, March
I
9.
so move.
Okay. Minister May, the second. We can take the meeting of March 10.
Chairman.
Yes, Mr. Jackson.
Pardon me, just slipped me. I just want to notice to the committee that, of course, while the opposition is in the main in concurrence as a team on much of the matters in the bill, there are certain clauses, particularly to deal with the sentences issue, which you know a few of us have very strong position concern on. Against that background, the opposition will be tabling a minority report, which I can serve notice will speak specifically to those issues.
Now, I kind of figured the past, because that's the area we have had, the primary year we have had any difference of opinion on. And not a hostile opinion, but policy difference on, all right? When you heard that, Mr. Richard, there was a motion, well, it's going the opposite direction to Mr. Jackson, but that we should amend, seek for a consequential amendment on the offense of person, that the minimum for murder should be moved from 15 to 20 years.
Oh, I'm sorry, Minister, I wasn't
I'm saying that there's a proposal
that
under the, it's the offense of persons, am I right? Legal? That we murder, currently the minimum for murder is 15. This felt we should ask for a consequential amendment to move that to 20, because you shouldn't have the minimum for firearm possession the same as the minimum for murder, which does make some sense. Well, Member Jackson, I take your comment and I think all the members know we did have a policy difference in terms of the minimum sentencing. So I would not take any umbrage to that position, and thanks for the information. We'll go forward and obviously further debate on the matter.
Indeed.
Which I think is...
And for whatever it's worth,
not a bad thing. No, it's a, we are not heavy ifs, you know. As I said before,
Yes,
so and therefore continuous debate and interrogation will only lead to better understanding and improvement in the long run. We have, you know, our concerns can be
and against that background, Chairman, I hope that between now and when the report is stable, you know, fellow colleagues, including yourself, will have greater reflections that would end up with some concurrence with us.
I gather you prayed this morning that we'll all have such reflection, and you're telling me, assuring me that you have a very, as a faithful servant, you tend to get responses to your prayer. But it's a difficult one.
In between now and the table of the report, I'll be even more.
All right, let me just go to the minutes. I said, Member Williams, move for confirmation, March 9, March 10. Yeah,
March
Member with Mr. Jackson, you move. Confirm by Mr. Main. The meeting on March 15.
March 15, let me see that one.
You're there, Mr. Williams. And
yes, I so move. That it be.
All right, Mr. Main was there too, so we'll take the same team. The meeting of the 16th, so the next day. Emma Jackson, you'll move for this one. So we have confirming this by a mix. You're there.
Yes, I was there.
Minister Williams will second that.
Yes, sir.
And the meeting of March 17, the short one, but you're there. Grant of Firearms authorized by the board. Continue this. We did this and we're almost unanimous on all this one. So again, Member Williams and Jackson, you can't move for confirmation and secondment.
Sure.
Yes, sir.
So do.
Meeting of the 23rd of March, that's when my Minister Ford chaired. 23rd. We approved the 17th, the 22nd.
We had a meeting on the 22nd.
Yes, we have a 22nd.
On the 23rd.
And I was present again. Senator Sinclair, you're present. You want to move for this confirmation? Seconded by.
So move.
Member Jackson.
So do.
The 23rd.
Can move for that one as well.
Member Williams, seconded by.
So move.
Senator Charles, Senator Charles Sinclair. The meeting of the 29th.
29th.
You're there again, Mr. Williams. You're a faithful servant. I think you attend all the meetings.
I'm not doing too bad.
Yes.
So moved.
Thank you. Seconded by member. Meeting of June 6th. Let me make sure these are the correct dates we have. Yeah, June 16.
Minister, Chairman, didn't we have, no, before we reach the 16th, didn't we have meetings on the 30th of March? 31st. I'm just looking on some notes that I have here.
Yes, Senator, pardon me, Chair, through you. We had, today is the 19th meeting for the committee.
Right.
So I tried my best to work on the minutes as well as the report. And some of my time was focused on completing the report for this meeting. So there are some minutes that I started and are incomplete. So that would have been a mistake, yes.
Okay. So you're not completed with the ones that the chairman is not referring to. You have not completed those. That's it.
So there are some in
I see.
the end of March and in May that we did that are incomplete.
I appreciate it. All right, thank you.
So there's a couple, well, yes, the 30th. There are 10 here. So there'll be about 9.
Yeah, you have dipped again, Mr. Chair.
There are 10 meetings here, I think, Ms. McCarthy. The 16th. We'll take the 16th that you have printed. That was us. And Member Williams and Member Jackson are both here.
Yeah, so moved.
Right? And the one of yesterday was the 21st. Similarly, Mr. Member Williams.
I wasn't there yesterday. No. I want to make a belated apology. Yes. I was to be there, but matters didn't allow.
What date are you referring to, Mr. Chair?
Yes.
The 21st, yesterday. So it would have to be yourself and Senator Sinclair to confirm.
Oh, very well.
Yeah.
Yes.
Sir, was there a confirmation for the 29th of March, sir?
29 March,
Yeah,
29.
29th of March, yes. That was Member Williams and Member Main.
Yeah, 29, let me see that one, 29th.
21st.
March 22.
We'll miss out from the 20th, 30th of March downwards till we get the 21st of June. Add all the minutes. They don't minutes. 16th of June, yes. We asked Member Williams and Member Main to confirm. And the last one we have is 21st of June, which was yesterday.
No.
No.
We're in July now.
21st of June, not July, the 21st
you
of
have,
June.
You have the 21st of June, the 22nd of June.
Yes, all of those coming down. But the last one I have printed here, no, not the last one, the minutes, the one that's missing, 22nd of June, etc. So we'll approve 21st of June.
So the 2 for June that are there, the 16th and the 21st, sorry.
Yeah, Member Williams and Senator Sinclair. But we have a number missing, about 7 or 8 of them.
8 in total, sir, plus today's meeting.
So we'll take those minutes procedurally in Parliament.
No, sir, I have to work on something with you, sir.
All right. Hold on. Before we sit. The report, we'll take the report now. We do it page by page. Page 1, report on the Joint Select Committee on its deliberation on this. It is shortly entitled the Firearms Prohibition, Restriction and Regulation Act 2022. Page 1 deals with the establishment, composition, in terms of reference of the committee.
Pardon me, sir. Mr. Richards, I think PBCJ had asked that we maximize the page a little.
Yeah.
Thank you.
All right. Page 1 is establishing the composition in terms of reference of the committee. Firearms Prohibition, Restriction, Regulation Act 2022. Read on Thursday, February 10, 2022, Honorable Dr. Arisa and CDMP Deputy Prime Minister and Minister of National Security, having obtained suspension of the standing orders, moved be it resolved that this Honorable House appoint a select committee comprising the following members. Yours truly, Minister Mali Malo Fort, Minister Pernell Charles, who have not had the chance of attending a single meeting. We bear that in mind for future committee members. Honorable Xavier Main, Member Mr. Mika Davis, MP Western Hanover, Mr. Donovan Williams, MP Central Kingston, Mr. Dwight Siblis, MP, Mr. Fitz Jackson, CD, and Mr. Lothian Cousins. We had changed that though, Mr. Jackson. Did we change Lothian? No, he came to the earlier one. We didn't come to the later ones.
Sorry, so repeat that last point.
Lothian Cousins, did he remain a member of the committee throughout?
Yes, he did.
Okay.
Yes, he did.
To sit joined with a similar committee to be appointed by the Senate to consider and report on the bill shortly entitled the Firearms Prohibition, Restriction and Regulations Act 2022. Be it resolved that the committee be empowered to hold virtual meeting, be they partly or wholly virtual from time to time. On Thursday, February 10, 2022, the Senator Camilla Johnson Smith, Minister of Foreign Affairs and Foreign Trade and leader of the government business, moved, be it resolved that Honorable Senate appoint select committee member comprising the following members: Honorable Senator Matthew Samuda, Senator Charles Sinclair, Senator Sharon Golding Campbell, Senator Peter Bunting, Senator Donna Scott Motley. Joined with a similar committee appointed by the House of Representatives to consider and report on a bill shortly entitled the Firearms Prohibition, Restriction, Regulation Act 2022. Members are reminded that the Senate Standing Committee Standing Orders 74B and C allow for members of the Senate to participate in meetings held in a virtual space created using information and communication technologies, ICT. Your committee members therefore as follows: named read before: Horace Chang, Marlene Malou-Fort, Prendel Charles Jr., Xavier Main, Tamika Davis, Donovan Williams, Dwight Sibley, Fitz Jackson, Lothan Jack Cousins, Senator Matthew Samuda, Senator Charles Sinclair, Senator Sharon Golden Campbell, Senator Peter Bunting, Senator Donna Scott Motley. Overall, your committee held 19 meetings to deliberate on the bill shortly entitled the Firearms.
Just to mention, I think Senator Motley's last name spelling is 1 T. If I recall.
Yes, it's supposed to be a hyphen between Scott and Motley. Yeah. Right. Thank you, Member Jackson.
Yes, sir. And my name, sir, is spelled with an O. Donovan, D-O-N-O.
Ah, Ms. McCarthy played better than mine.
Very good. Now I see the amendment.
Yes. Your committee held 19 meetings to deliberate on the bill shortly entitled the Firearms Prohibition, Restriction, Regulation Act 2022, commencing during the 2022-2023 parliamentary session on February 15, 2022, including virtual and hybrid meetings. We completed our deliberation on the bill on July 20, 2022, Appendix 1. At its first sitting, the committee agreed to allow stakeholders and the wider public to make submissions on the bill. In that regard, a total of 6 public notices inviting written submissions from individuals and organizations were placed in the print media, Jamaica Observer and the Gleaner, on Sunday, February 20, 2022, Sunday, February 27, 2022, and Wednesday, March 2, 2022, with a deadline for submission to be made by Thursday, March 10, 2022. Public notices were also posted on the parliamentary social media pages. Your committee received a total of 16 submissions from the following organizations and individuals: Jamaica Customs Agency, Jamaica Defense Force, Proactive Jamaicans, Jamaica Rifle Association, Jacks Bay Hunting and Fishing Club, Shalani Gun Club, Jamaica Bar Association, the law offices of Mr. Peter Champagne and Company, Licensed Firearm Holders of Jamaica, Life Jam, Cornwall Bar Association, Mr. Jean-Pierre Lifshan, Mr. Michael Todd, Mr. Kanyut Ramsey, and Mr. O'Shane Wright and Mr. Zach Chen.
Is that Ramsey or Bushy? Or is it
Mr. Kanyut Bushy, sorry. Yes, Mr. Kanyut Bushy. Says Jean-Pierre Lifshan, Mr. Michael Todd, Mr. Kanyut Bushy, Mr. O'Shane Wright, and Mr. Zach Chen. We received all presentations from Jamaica Customs Agency, Jamaica Rifle Association, and Mr. Peter Champagne and Company. Technical teams were present from the Ministry of National Security, the Ministry of Justice, the Jamaica Constabulary Force, the Firearms Licensing Authority, the Institute of Forensic Science and Legal Medicine, the Office of the Parliamentary Council, Attorney General's Chambers, and the Legal Reform Department. There was a separate technical team from Legal Reform from Justice, Ms. Wilkins.
I'm sorry, Chair. Could you repeat that question?
I said it is listed technical teams from the Ministry of Justice and the Legal Reform Department. There was an additional technical team outside the Legal Reform Department.
Well,
PSK?
No, Minister.
No, I thought it was the Ministry of National Security, Ministry of Justice. So in fact, Legal Reform
But Legal Reform Department isn't in the Ministry of Justice anymore.
Oh. Legal Reform is now with Legal Affairs.
Correct.
I see you migrated to Ms. Wilkins.
We sit separately.
Pardon me, sir.
And
I think Mr. Bailey would have
Mr.
been
Bailey,
what I referred to from
Yes,
Ministry
yes.
of Justice.
Oh, so it will be both. Yes.
Okay.
So it's fine.
Overview.
Sorry, Mr. Chairman, a query.
Sure.
I don't know. Probably it's a matter of, I don't know. I suppose Ms. McCarthy can say, because she oral presentations. Didn't we get an oral presentation from a superintendent? I can't recall the name now, but
Legal medicine.
or is he just going to be?
Well, I'm not sure. Was it Institute of Forensic Science and Legal Medicine made a full presentation?
Yeah, I think he was from that group, from that institute.
Yeah.
Oh, but
was
can I
it?
clarify, Minister?
Yeah.
So it wasn't an oral submission. He was invited to make a technical presentation.
Okay.
Yeah, it's a technical presentation. I want to separate from an oral presentation on the bill. All right.
Thanks.
He outlined the whole forensic unit of yours. Very, very good presentation, if I recall correctly.
Well, just to clarify, Senator Charles Sinclair, it's just, well, he would have, as Mr. Richard said, listed in the technical teams, but the oral presentations would have been from those persons who made submissions to the bill.
Thank you.
I think that's coming true.
Yes. Overview. Your committee was advised that the decision to repeal and replace the Firearms Act had been advanced within the context of the policy position that a framework should be developed to deal with firearms duly registered by the Firearm Licensing Authority, FLA, distinct from those which would have been illicitly manufactured and trafficked and had never been subject to a regulatory regime. We were also advised that the proliferation of firearms resulted in increased access in Jamaica and was a direct catalyst for murders committed. Your committee was provided with statistics indicating that the firearms were used to commit 85% of the 1,463 murders recorded for 2021, with a further 1,258 persons shot and injured. In 2021, a total of 624 firearms were seized, along with 8,808 assorted rounds of ammunition, when compared to 623 firearms seized at the end of 2020, with 10,146 rounds of ammunition seized. We learned of the issues identified, including operational challenges faced by the FLA, enforcement issues experienced by the Jamaica Constabulary Force, JCF, and the Office of the Director of Public Prosecutions, ODPP, in executing their respective duties based on the limitations of the Firearms Act of 1967, as well as the need to incorporate the provisions of existing international instruments to which Jamaica is a signatory or party. Your committee was informed that the new framework was seeking to establish a regime that targets unregulated firearms and the activities connected thereto, to include illicit trade, manufacture, stockpiling, possession, and those illicit firearms. A regime to address regulated activities in relation to the manufacture, trade, possession, and use of firearms and ammunition in Jamaica, and creating offenses for breaches of the regulatory regime, and penalties that are appropriately dissuasive and commensurate, particularly in respect of unregulated firearms. We were also informed that the general objective of the Act was to establish a framework which prohibited firearms and ammunition that were illicitly traded and which regarded possession of those prohibited firearms and ammunition as the foundation on which other heinous and violent crimes were committed. The bill entitled the Firearms Prohibition, Restriction and Regulations Act 2022 seeks to eliminate the illegal possession, manufacture, trafficking, proliferation, and use of prohibited weapons, particularly through the provision of appropriate penalties which deter such activities, provide for and promote the effective management and regulation of the firearm industry through the establishment of a robust licensing regime, establish standards that were in keeping with internationally recognized norms and best practices for the firearm industry. Regulate the lawful manufacture, trafficking, possession, and use of firearms and ammunition in the interest of personal and public safety, and align the legal framework in respect of firearms and ammunition with Jamaica's international treaty obligation. 3, finding and recommendation. The committee, after extensive review of the bill, now has the honor of presenting its findings and recommendation. Part 1, preliminary. Clause 1, short title and commencement. Your committee notes that there are no proposals for clause 1 and agrees that the clause should remain as is. Clause 2, interpretation. Your committee agrees to amend the definition of acquire to mean A, accept as a gift, B, borrow, C, receive, or D, come into possession if any circumstances specified in section 46(1). Your committee agrees to insert a definition for assorted part to mean any item that can be attached to a firearm or prohibited weapon and that increases its usefulness or effectiveness, but which is not essential for the ordinary use of that firearm or prohibited weapon. Your committee agrees to amend the definition of automatic firearm to mean any firearm designed or adapted so that if pressure is applied to the trigger, projectiles continue to be discharged until pressure is removed from the trigger or the magazine containing the projectiles is empty. Your committee agrees to the definition of firearm is amended as A means any one barreled weapon which discharges or is designed to discharge any shot, bullet, or projectile, or 2, prohibited weapon unless the context otherwise requires and includes any such weapons created as 3D printed weapons or otherwise created through the use of first square brackets and
that's the first square bracket. I would think you would need the use of electronic software to cover all software present and future. In that case, you would need similar technology because the printer is better. Right?
So we would remove similar technology and retain the words electronic software, and consequently, we can remove the square brackets there. B, includes any parts and components of any weapon referred to in paragraph A, and C, does not include an air rifle, air gun, or air pistol of a type or caliber prescribed by the minister. Your committee agrees that the definition of firearm and tool mark examiner is amended to mean a person who is experienced and competent in A, the identification, collection, preservation, examination, and interpretation of tool marks, firearms, ammunition, and ammunition-related components, or B, the analysis of the sequence of events relating to a shooting incident. Your committee agrees that the definition of firearm shooting range is amended to mean a facility operating pursuant to a firearms shooting range license, and A, managed by at least one supervisor authorized for that purpose by the authority, and B, designed for shooting practice for firearms of such type and at such place as may be specified in the license. Your committee agrees that the definition of firearm user's license is amended to mean a license authority authorizing the holder to possess such firearm or ammunition as is specified in the license. Your committee agrees that the definition of firearm user's permit is amended to mean a permit authorizing an individual not younger than 12 years of age and not 21 years of age or older to possess and use a shotgun, air gun, or ammunition with the permission of the principal holder of the firearm user's license for that shotgun, air gun, or ammunition as the case may be. Clause 2, interpretation, continue. Your committee agrees that the definition of gunsmith's license is amended to mean a license authorizing the holder thereof to A, test, deactivate, modify, or prove any firearm or ammunition in accordance with sections 42 and 43, or B, convert or modify any firearm or ammunition in accordance with section 44. Your committee agrees that the definition of imitation firearm is amended to mean anything which has the appearance of being a firearm but is not a firearm, whether or not such imitation firearm is capable of discharging a shot, bullet, or other projectile. Your committee agrees the amended definition of modification in relation to firearms or ammunition. A means any act that results in a difference in appearance, function, or performance of the firearm or ammunition. B includes alteration and effecting repairs, and C does not include changing the choke on a shotgun. The committee agrees that the definition of parts and components means any items or replacement items specifically designed for a firearm and essential to its operation, and includes A, barrel, frame, or receiver, slide, cylinder, magazine, firing pin, mainspring, bolt, or breech block. B, any part designed solely or exclusively for converting a semi-automatic to an automatic firearm. And C, any device designed or adapted to diminish the sound caused by firing a firearm. Your committee agrees that the definition of 3D printed firearm means a barreled weapon which discharges or is designed to discharge any shot, bullet, or other projectile, and that is mostly produced or manufactured with a 3D printer or any type of electronic software. Your committee agrees that the definition of trade in firearms or ammunition is amended to mean any activity for which a firearm broker's license or firearms dealer's license is required under this act. Your committee agrees that the definition of transferring should be amended to include A, giving, B, lending, or C, parting with possession. Clause 3, objects. Clause 4, application of parts 2 and 4. Your committee notes there are no proposals for clauses 3 and 4 and agrees they should remain as is. Part 2, prohibitions in respect of firearm and ammunition. Clause 5, possession of prohibited weapon. Clause 6, stockpiling. Your committee notes there are no proposals for clauses 5 and 6 and agrees they should remain as is. Clause 7, trafficking in prohibited weapon. Your committee agrees that subclause 7.2 should be amended to read, a person who contravenes subsection 1 commits a felony and shall on conviction therefore before a circuit court be sentenced to imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify the term of imprisonment being a term of not less than 20 years that the person shall serve before being eligible for parole. Part 2, prohibitions in respect of firearms and ammunition. Clause 8, possession of prohibited weapon with intent to traffic. Your committee agrees to amend the term of imprisonment in subclause 8.2 to read 20 instead of 15 years. Clause 9, manufacture of prohibited weapon or possession of device, therefore. Your committee agrees to amend the term of imprisonment in subclause 9.2 to read 20 instead of 15 years. Your committee also agrees to amend subclause 9.3 to read, no person shall possess a digital blueprint of a prohibited weapon, or B, a digital blueprint of any device with the intent to manufacture a 3D printed firearm that is a prohibited weapon. Clause 10, dealing in prohibited weapon. Your committee agrees to amend the term of imprisonment in subclause 10.3 to read 20 instead of 15 years. Clause 11, prohibition on taking firearm or ammunition in pawn. Your committee notes there are no proposals for clause 11 and agrees the clause should remain as is. Clause 12, prohibition on diversion. Your committee agrees to amend subclause 12.1 by inserting the word shall, the words, and a comma in furtherance of a criminal purpose. We also agree to amend subclause 12.2 by deleting the words to a fine or after the word court in the second line. Clause 13, prohibition on alteration of ballistic signature, conversion of firearm or prohibited weapon, etc. Your committee notes the editorial amendment in the marginal note of clause 13 by adding the word etc. after the word weapon. Your committee agrees to amend the term of imprisonment in subclause 13.2b to read 20 instead of 15 years. Your committee agrees to insert new subclause 13.3 and 13.4 as under. 3, no person shall possess any assorted part for a prohibited weapon or without the appropriate firearm authorization possess any assorted part for a firearm. 4, a person who contravenes subsection 3 commits an offense and shall be liable on conviction, therefore, before a parish court to a fine not exceeding $5 million or to imprisonment for a term not exceeding 5 years. Clause 14, use or possession of firearm or imitation firearm in certain circumstances. First schedule. Your committee agrees to amend subclause 14.4 by deleting the words to a fine or and increasing the term of imprisonment to 20 years. Part 2, prohibitions in respect of firearms and ammunition. Clause 15, possession of firearm or ammunition with intent to injure or cause damage. Clause 16, removal, alteration, etc. of a mark. Clause 17, transfer in violation of United Nations Security Council resolution. Your committee notes there are no proposals for clause 15, 16, and 17 and agrees the clauses should remain as is. Continuing part 2, prohibitions in respect of firearms and ammunition. Clause 18, offense of seeking benefit, etc. through professing to have or to have access to firearm. Your committee notes the editorial amendment in the marginal note of clause 18 by adding the word etc. after the word benefit. We agree to amend subclause 18.1 by inserting the words or cause apprehension to any person. Clause 19, power of minister to declare firearms amnesty. We agree to amend subclause 19.3b to read, may if the firearm or ammunition is of a type in respect of which a firearm authorization may be granted under this act. We also agree to amend subclause 19.4 by substituting the word firearm for the word firearms in the first line. Part 3, firearm licensing authority. Clause 20, establishment of the firearm licensing authority, second schedule. Your committee agrees to amend the SHAPU to clause 23 by deleting the word licensing in the second line and substituting therefore the words handling of firearms and ammunition and the. We also agree to amend subclause 23K, inserting after the word firearm, the word and maintaining records in relation to such marking. We agree further to insert a new subclause 23O to read, maintaining records in respect of firearms authorization and in respect of reports furnished by firearms dealers relating to the sale of firearms, and we note the subsequent renumbering of the remaining clause as subclause 23P. Clause 21, Board of Directors, third schedule, Board of Authority. Clause 22, functions and powers of board. Your committee notes there are no proposals for clauses 21 and 22 and agree the clauses should remain as is. Clause 23, Chief Executive Officer, third schedule. We agree to amend subclause 23(1)C to read, in particular, carry out the functions listed in subsection 3. Clause 24, delegation of functions of chief executive officer. Your committee agrees to amend subclause 24.1 by deleting the word employees and substituting therefore the words members of staff. Clause 25, ministerial direction. Your committee notes there are no proposal for clause 25 and agrees that the clause should remain as is. Clause 26, funds of authority. Your committee agrees to amend subclause 26.3 by deleting the word responsible and substituting therefore with responsibility. Part 4, restriction in respect of firearms and ammunition. Clause 27, declaration of firearms that may be imported or exported. Your committee agrees to amend clause 27 by inserting a comma and the words the institute after the word authority. Clause 28, National Firearm Control System and Firearm Control List. Your committee notes there are no proposals for clause 28 and agrees that the clause should remain as is. Clause 29, marking of firearms. Your committee agrees to amend the Shapiro of clause 29.1 by inserting the words the mark of the manufacturer and after the word bearer. Clause 30, addition, modification, etc. of a mark. Your committee notes the editorial amendment in the marginal note of clause 30, which now reads addition, modification, etc. of a mark instead of removal, alteration, etc. of a mark. We agree to amend subclauses 32A1 and 32A2 to read the addition or modification of a mark on a firearm, A, may be done to correct evident errors in the marking on the firearm and shall only be made by 1, an authorized officer or a gunsmith at the direction of the authority, and the authority shall forthwith notify the registrar of the addition or modification as the case may be, or 2, an authorized officer at the direction of the director of the institute. We also agree to amend subclauses 32B and C to read. B, may be made for the purpose of facilitating the deployment of government-owned firearms by an officer of the institute authorized by the director of the institute. C, in the case of a firearm recovered by the police in the course of an investigation, may with the authorization of the Commissioner of Police be made for evidentiary purposes by a constable acting in the course of his duties, and the Commissioner shall forthwith notify the registrar of the addition or modification as the case may be.
Minister, excuse me, through you, Chair, Ms. Cunningham has her hand raised.
Oh, yes, you're recognized.
Cunningham. Ms. Cunningham? I think her hand was up before. Ms. Cunningham? We're back to the next page, I think. Not hearing her, Anita. Sure.
You're continuing. Your committee agrees to further amend subclause 33 to read, where the registrar receives a notification under subsection 2A1 or B, or directs an addition or modification under subsection 2A2, the registrar shall make such corrections to the information recorded in the register pursuant to section 29 as may be necessary. Clause 31, capture of ballistic signature and other information in relation to firearms. Clause 32, duty of importer or manufacturer to deliver firearm to be marked, etc. Clause 33, restriction on trafficking in firearms and ammunition. Your committee notes there are no proposals for clauses 31 to 33 and agrees the clauses should remain as is.
Pardon me, sir. Ms. Cunningham says she notes a square bracket at 29(1)B where it says the name of manufacturer. Mr. Richards, I'm not sure if you've seen on your proposed amendments, not in the report necessarily.
Yeah, sorry, if I might. I think we can ignore those square brackets and have removed them because the provision was there originally.
Thank you, Ms. Grant.
Clause 34, importing a firearm. Yes, no problem. Importing a firearm that does not bear the required mark. Your committee agrees to amend clause 34 to read, a constable, customs officer, or authorized officer shall detain any firearm imported into Jamaica that does not bear the mark required under section 29(1) or 2. Part 4, restriction in respect of firearms and ammunition. 35, clause 35, requirement for traveler to declare firearms and ammunition. Clause 36, the duty of traveler in respect of declared firearms and ammunition. Your committee notes there are no proposals for clauses 35 and 36 and agrees the clauses should remain as is. Clause 37, procedure in respect of firearm and ammunition delivered sealed by traveler. Your committee agrees to amend subclause 37(2) by substitute.
Sorry, Mr. Chairman and all of this is a draft, I appreciate, right? But wasn't there are we just making a note because we don't want this to be going towards the final? Is there going to be some, the SG had made some comments in respect to building out 30, is it 34, 30? 36. Was it 33 or 35? 36. Regarding it?
36.
It was 36?
It was 33 and 36.
So is that, how are we, since we are putting forward this to say that this is the report, how do we?
There is a proposal for change in 36, but not 35. Yeah, 36. We'll have to amend this. There are none for 35.
So in effect, what I'm saying is that in this particular area where we have these clauses, that was the SG had commented on earlier today.
So we'll have to revert to clause 36. The exact wording is not yet available. So
or something, some notation.
Yes, so we'll make a note. So we continue with clause 37, procedure in respect of firearm and ammunition delivered sealed by traveler. Your committee agrees to amend subclause 37(2) by substituting the numeral 103 for the numeral 102 in the last line. Clause 38, restriction on manufacture of firearms and ammunition. Your committee agrees to amend subclause 38(1) to read, no person shall accept under and in accordance with a firearm manufacturer's license granted under Part 5, A, manufacture any firearms or ammunition, or B, possess a device with intent to manufacture any firearm or ammunition. Clause 39, restriction on testing, etc. of firearms or ammunition. The committee agrees to amend subclause 39(1) by deleting the words for another person after the word ammunition. Clause 40, restriction on dealing, etc. in firearms and ammunition. The committee agrees to amend subclause 43(b) by inserting the words without the appropriate firearm authorization after the word ammunition in the first line. The committee also agrees to amend subclause 46 to read, no person shall transfer any firearms or ammunition to or accept a transfer of any firearms or ammunition from an individual whom the person knows or has reasonable cause to believe to be under the age of 21 years. So we'll remove those. Yes.
There's a discussion on this, if I recall correctly. In 21, the appropriate limits, except in accordance with the firearms permit granted to that individual. I remember vaguely discussion because there's something you have to, it's a regulated firearm and should the 18-year-old be allowed as adults. This is why this was put in, the 21 was put in here. The committee member recall, or when the concerns, we keep that 21 or we move to 18 in accordance with the legal common law provisions. Senator Sinclair, feeling about this? Legal mind.
Sorry, I'm not hearing you clearly.
I'm saying this clause is really suggesting the transfer or procurement or even a license for no one under the age of 21. And those in a square bracket, I think it was brought up there because the age of responsibility is 18. Do we keep this at 21 or remove the square bracket? Or do we move it to 18? No person shall transfer any firearm or ammunition to or accept transfer of any firearms or ammunition from an individual whom the person knows or has reasonable cause to believe to be under the age of 21, except in accordance with the firearms user's permit granted to that individual.
Isn't there an age where you cannot have a firearm, save and except?
You don't get a license below 18, you have to get a permit. That's 18.
Is it 18?
18, yeah. Yeah.
You can,
21 years in the
it is that you can get a permit, but not a license.
A permit, 21.
So, except in accordance with the firearm user's permit. So, well, right. So,
Mr.
there's an exception to it. So, I think it would remain as 21.
Yeah, Mr. Richards.
Right. I think Senator Sinclair was just pointed out because if we were to change this to 18, we'd have to then make the consequential change.
No, it remains at 21.
Right.
Yeah.
Remove the square bracket.
We proceed now to clause 41. Purchase, acquisition, and delivery of firearms and ammunition. Your committee agrees to amend subclause 41(1)(c) by deleting the word and substituting therefore the words a firearm before the word authorization. Clause 42, restriction on modification of firearm by gunsmith. Your committee agrees to amend subclause 42(2) by deleting the words as soon as possible and substituting therefore the word forthwith. Clause 43, sale, testing, deactivation, modification, and proofing of firearms and ammunition, requirements for holders of gunsmith's license. Your committee agrees to amend subclause 43(1)(d) by deleting the word under and substituting therefore the word in. Clause 44, approval for modification or conversion of firearm, etc. Your committee notes there are no proposals for clause 44 and agrees the clause should remain as is. Clause 45, unauthorized possession of firearm or ammunition. Your committee agrees to amend clause 45 by deleting subclauses 45(3) and 45(4). We agree to insert thereafter the words for the avoidance of doubt where any firearm or ammunition is carried in parts by 2 or more persons in company. Each such person shall be deemed to be in possession of a firearm or ammunition within the meaning of this act. Clause 46, exceptions to restriction on possession of firearm, ammunition, etc. Your committee agrees to amend subclause 46(1)(d)(1) to read the personal representative of any estate of any deceased person who, or 47, clause 47, restriction on carrying firearm or ammunition in a public place. The committee agrees to amend clause 47 by inserting a new subclause 47(3), which reads, where a person is unable to produce the appropriate firearm authorization when so required under subsection 1, but is able to satisfy a constable as to the person's name, address, and identity, and that the person is in fact the holder of a firearm authorization, A, the constable shall retain the firearm or ammunition as the case may be and permit the person to produce the firearm authorization within 24 hours thereafter at such police station as may be specified by the constable at the time when the firearm authorization was required to be produced under subsection 1. And B, if the firearm authorization is produced pursuant to paragraph A, that person shall not be liable to be convicted of an offense under subsection 2, and the firearm or ammunition, as the case may be, shall be returned to the person. Clause 48, requirement applicable to a person authorized to carry a firearm in public place. Your committee agrees to amend subclause 428(1) to read, where any person carries a firearm in a public place pursuant to a firearm authorization, authorizing that person to carry the firearm in that public place, the person shall conceal the firearm and shall not intentionally expose the firearm except in the circumstances set out in section 51(1)(a), (b), or (c). Clause 49, restriction on carrying firearm or ammunition in a security restricted area. Clause 50, declaration of security restricted area. Your committee notes there are no proposals for clauses 49 and 50 and agrees the clauses should remain as is. Clause 51, restriction on discharge of firearm. Your committee agrees to amend clause 51 by inserting a semicolon and the word or after the word authority in subclause 51(1)(c). We also agree to insert a new subclause 51(1)(d), which reads, as otherwise permitted under any law. Square bracket. We agree further to amend subclause 51(2) by deleting the words, and shall be liable on summary conviction, therefore, before a parish court to a fine not exceeding $3 million or to imprisonment for a term not exceeding 3 years, and agreed the penalty provision should be removed to the 6th schedule. It was deleted. Okay.
Sorry, may I, Ms. McCarthy, can you say why you have that in square brackets?
It was there before, so the new version of the things that you sent to me today is different, and I had sent this before, so I'll delete it.
Okay.
Okay.
So it's deleted. Move on to clause 52. Yes. 52, duty to deliver firearms and ammunition. Your committee agrees to amend the chapter of clause 52(1) to read, subsection, subject to section 54, a person who comes into possession of any firearm or ammunition shall forthwith, unless the person has the appropriate firearms authorization in respect thereof, deliver the firearm or ammunition as the case may be. 2, we agree to amend subclause 52(5) as follows. A statement may not—
Sorry, just a second, just to point out a typo, to make sure we bring it to the attention of the typo with the word forthwith.
Are you referring to the
52,
same? Yes.
Clause 52(1), there's a typo, the word forthwith with the spelling. It has FORHWIA.
So Nadine, I think you're looking at the draft. I think the draft that Ms. Grant's latest draft has it corrected.
Okay.
When was the latest draft sent out, CTD?
Last night.
Oh my goodness.
Okay, forthwith,
Oh,
yes.
I do beg
It
your
has been
pardon.
corrected. I'm sorry, guys. Yes.
So, can't keep printing.
All right.
Oh, all right.
We agree to amend continuing subclause 52(5) as follows. A statement may not be used by virtue of subsection 4B against a person unless A, evidence relating to the statement is adduced, or B, a question relating to the statement is asked by that person, or C, on that person's behalf in the proceedings arising out of the prosecution. Clause 53, duty to report loss or theft of firearm or ammunition. Your committee agrees to amend subclause 53(1) to read, the holder of a firearm in respect of any firearm or ammunition that is lost or stolen shall forthwith, upon discovering the loss or theft, report the loss or theft to the police. Clause 54, duty to report possession or knowledge of location of lost or stolen firearm or ammunition. Your committee agrees to amend subclause 54(1)(a) to read, forthwith upon coming into such possession, report the matter to the police. and we also agree to amend subclause 54.3 by deleting the words within 24 hours after the person acquires and substituting therefore to the words forthwith upon acquiring. Clause 55, court may declare restricted person. Your committee notes there are no proposals for clause 55 and agrees the clause should remain as is.
Rotate this. That's what healthy again. So try to keep it. Part 5, firearm authorization. Clause 56, prohibition on grant of firearm authorization contrary to international obligations. Your committee agrees to amend clause 56 by deleting the word weapon and substituting therefore the word arms. Clause 57, application to authority for certain firearm authorizations. Your committee notes there are no proposals for clause 57 and agrees the clause should remain as is. Clause 58, grant of firearm authorization by the board. Your committee agrees to amend subclause 58(1)(b) to read by deleting the word cabinets and substituting therefore the word the ministers. We also agree to a new subclause 58(3)(d) to read to a person who is charged with or detained in respect of an offense involving domestic violence. The subsequent clauses are amended to read subclause 58(3)(e) to an applicant who the board has reasonable cause to believe is unfit to hold a firearm authorization, and in determining that question, the matters that the board may have regard to include: 1, whether the person is of intemperate habits; 2, whether the person is suffering from a mental disorder as defined in Section 2 of the Mental Health Act; and 3, whether the person has a history of A, mental health issues; B, drug or substance abuse; C, domestic violence, or which would cause the person to be unfit to be entrusted with such firearm or ammunition, and the board may require the applicant to undergo psychometric testing as part of the requirements for determining whether to grant the authorization. Subclause 58(3)(f). Unless the board is satisfied that the applicant is a person who can be in possession of a firearm or ammunition without danger to any person or to public peace or public of safety. 2, as to the applicant's proficiency in the use and management of the type of firearm in respect of which the applicant's application is made. 3, that the applicant has made adequate provision for the safekeeping of the firearm and ammunition in respect of which the application is made, having regard to the firearm authorization applied for; and 4, that the applicant resides or is ordinary resident in Jamaica, except in the case of an application for a firearm user special certificate. Part 5, firearm authorization. Grant of firearm authorization by board continued. Subclause 58(3)(g). In the case of an application for a firearm manufacturer's license, the board, one, is satisfied that the other requirements specified in this section for the grant of the license are met, and having recommended pursuant to Section 61 that the license be granted, is informed of the minister's approval of the recommendation. Subclause 58(3)(h), where the firearm in respect of which the applicant is made to the authority is already in the possession of or control of the applicant, unless the applicant has made the firearm available to the authority for inspection. And subclause 58(3)(1)(i), unless the applicant has paid the appropriate application fee. Your committee agrees to insert the words "in writing" after the word "time" in the first line of the new subclause 48(4). We also agree to insert the words "except in the case of an application for a firearm manufacturer's license" after the word and the second line of subclause 58(4)(a). The subsequent subclause was renumbered as the new subclause 58.5. Clause 59, grant a firearm export permit. Your committee notes there are no proposals for clause 59 and agrees the clause should remain as is. Clause 60, grant a firearm manufacturer's license. Your committee agrees to delete subclauses 62 and 60, bracket 3, and substitute thereof, therefore, a new subclause 62, which reads, the minister, on receiving recommendations under subsection 1, shall, A, if the minister decides to approve the recommendation, inform the board of the decision, and B, if the minister decides not to approve the recommendation, inform the board of the decision.
Sorry, Mr. Chairman.
Yeah.
A quick recommittal and probably for my personal clarification.
Yeah.
When we were dealing with what is it now?
The authorization by the board?
No, man. The board shall within the section that deals with the approvals by the board.
Should give a time limit. Just what
We were
time
looking
limit
at the time limit. I noticed that we had come to, I think you had accepted the position that there should be some time.
Yes,
and the question,
although
but I don't see anything that is referencing here, whether we were going to put it elsewhere, change it, but I think all persons, the committee in general, had accepted that there should be some time.
Minimum service standards.
I don't see any reference to it.
The chairman indicated there would be online tracking very soon, but we wanted to see it clearly stated as that there is some minimum levels of service standard. It would be way back, you know. In the way.
And no, I think that was in
approval.
In the approval section, which is 50 in the 58. And in the draft bill, we're actually dealing with 50. What is 58.5?
Yeah, grant of
it has spoken about reasonable time, and I think the majority of persons was
we did agree on a time
that there should be some time and so forth, but I don't see
at least a notice sent to them.
Anything comment anywhere in the report on that issue.
So, Mayor Chairman,
yeah, Mr. Richards, yes.
Just point Senator Sinclair to clause 106, where this developmental service standards framework was inserted to take particular consideration of that reasonable time. I think we had come around to including that provision so that the minister may from time to time make that, give that directive to the authority to state that time in terms of the period of time it will take to give notice. Sorry.
Understood. Take your time. Don't go too fast. I think so. It should be covered in 106 when we get there. Then take a look at it. Because I think it was discussed in the broader context of establishing service standards to the public by the institution. So not only in authorization, but I think that there should be a time limit for you to inform the applicant or the whoever, you know.
That is correct, Mr. Chairman. So it just that we had gotten past there, and I did not see any indication. We were going. The report is going clause by clause, so I thought it would have been there. But if it is further on, fine.
Right. We'll bear that in mind because the idea of establishing service standards appeals, so we think we have to do it in these, once you get in the regulatory side. And while it could be amended by the minister, it has to be stated at the beginning, and we can maybe advance it. If we say 90 days, no, once you get the electronic moving tracking going, you can make it less. But the idea is that contact should be made with the applicant at a minimum time. Even if you're not granted, you say, look, we are still at the stage of investigating or something, so that they are aware that they're not lying in file 13 somewhere. That was the purpose of this minimum standard.
Yes, sir.
It make a lot of sense. All right. Clause 61, grant a firearms users employees certificate. Clause 62, grant a firearms user special certificate. And clause 63, grant a firearms user special permit. Your committee knows there are no proposals for clauses 61, 62, 63, and agrees that the clauses should remain as is for them. Clause 64, grant a firearm disposal permit. Your committee agrees to insert a new subclause 64(1)(b) to read, is the executor of the estate of a deceased holder of a firearm authorization acting with the consent of the person entitled to claim ownership of the firearm under the estate of the deceased and who submits with the application proof in writing of such consent, and the subsequent subclause amended accordingly. Clause 65, grant of antique firearm collector's license. Your committee knows there are no proposals for clause 65 and agree that the clause should remain as is. Part 5, continue, firearm authorization. Clause 66, form of firearm authorization. Your committee agrees to insert a new subclause 6610, which reads, every firearms user's secondary certificate shall specify the firearm or ammunition that the holder thereof is authorized to be in possession of or use, being a firearm or ammunition that is the subject of the relevant firearm user's license permit. The subsequent subclause were also amended accordingly. Clause 67, application to minister for a certain firearm authorization. Clause 68, grant of firearm authorization by minister. Your committee notes there are no proposals for clause 67 and 68 and agrees the clauses should remain as is. Clause 69, firearm destruction authorization and ammunition destruction authorizations. Your committee agrees to amend subclause 69(1)(b) by substituting numeral 103 for the numeral 102 in the last line. We also agree to amend subclause 69(2)(b) by deleting the word 3 and substituting the word 5. Clause 70, duration of firearm authorization. Your committee agrees to amend subclause 71 to read, a firearm authorization granted under this part other than a permit or certificate shall, unless otherwise provided by the Act, continue in force for a period not exceeding 5 years. We also agree to delete subclause 73. Renewal of authorizations. Your committee notes that the amendment of the marginal note to read renewal of authorizations. We agreed to amend the chapeau of subclause 71 to read, a firearm authorization granted under this part other than a permit or certificate may be renewed by the board if. We also agreed to amend subclauses 71(1)(a), 71(1)(d), 71(1)(e), and I by deleting the word license and substitute the word therefore the word authorization. We agree further to insert the words the authorization after the word of subclause 71(1)(e) and 2. Roman numeral 2. Your committee agrees further to amend subclause 71(2) to read, the duration of a firearm authorization on renewal shall be A, 5 years in the case of a firearm user's license or a firearm business license, and B, in the case of any other firearm and authorization that may be renewed under this section. Such period shall be specified by the board upon granting the renewal. Your committee agrees to amend the subclause 71(3) by deleting the words a license and substituting therefore the words firearm authorization. Your committee also agreed to amend subclause 71(4) to read, on receipt of the notice under subsection 3, the holder of the firearm authorization shall, without prejudice to any appeal that may be made under this act, forthwith surrender the firearm authorization to the authority, together with all firearms and ammunition in the possession or control of the holder, and to which the authorization relates. Your committee agrees further to amend subclause 715 by deleting the word license and substituting the words firearm authorization. Clause 72, amendment of terms and conditions of firearm authorization. Your committee agrees to amend subclause 72(2)(a) by deleting the words proposed after the word variation. Continuing obligation of the holder of firearm authorization. Clause 73, registration of firearm. Your committee agrees to amend subclause 73(3) by inserting the word person. The words having regard to the matter set out in section 58(3) and 4. Your committee agrees to amend the subclause 73(5) by inserting after the word who, the words without reasonable excuse. Also agreed to insert a new subclause 73(6), which reads, where a holder is unable to produce the firearm within the period specified in subsection 2 and is able to satisfy the authority that there is reasonable excuse for the inability, and A, the authority should permit the holder to produce the firearm within which time, as shall be specified by the authority. And B, if the firearm is produced as specified under paragraph 8, that person shall not be convicted of an offense under subsection 5. Clause 74, duty to store firearm and ammunition.
Sorry, Chairman, just a slight correction. That provision should read, shall not be liable to be convicted of an offense under subsection 5 for consistency with the other provision.
A person shall not be liable
to be convicted.
To be convicted. Please accept the notation here. Yes, it's more consistent. That is okay. That is in clause 373. Clause 75, special restriction upon holder of firearm manufacturer's firearm broker's license or firearm dealer's license. Your committee notes there are no proposals for clauses 74 and 75 and agree the clauses should remain as is. Clause 76, records to be maintained by a relevant license. Your committee agrees to amend subclause 76(5)(4) by inserting after the word authorized the words in writing. Relevant license, clause 77, relevant license to display notice. Clause 78, contravention of terms or conditions of firearm authorization. Your committee knows there are no proposals for clause 77 and 78 and agrees the clause should remain as is. Clause 79, temporary storage or custody of firearms or ammunition. Fourth schedule, your committee agrees to amend subclause 79(1) by deleting the words firearm user's license in the first line of the chapeau and substituting therefore the words firearm authorization, permitting that person to be in possession of a firearm or ammunition, and substituting the word authorization for the word license on the third line. Your committee agrees to amend the subclause 79(2) by deleting the words firearm user's license in the first line and substituting therefore the words firearm authorization, permitting the person to be in possession of a firearm or ammunition, by substituting the word authorization for the word license in the third line. Clause 8, surrender of license, firearms, and ammunition. Your committee agrees to amend clause 80 to read, the holder of a firearm authorization permitting that person to be in possession of a firearm or ammunition shall, if the holder A wishes to surrender the license, or B ceases to operate the business to which the authorization relates, surrender the authorization, deliver all firearms and all ammunition to which the authorization relates to an employee of the authority authorized to receive them. Clause 81, storage fees, release of firearms and ammunition from storage. Your committee agrees to amend subclause 81(1)(a) by deleting the words firearm user's license and substituting therefore the words firearm authorization. Clause 82, delivery of firearms and ammunition to appropriate authority for safekeeping. Your committee agrees to amend the clause 82.1 by inserting the words public before the word safety in the second line. We also agree to amend subclause 82.4 by substituting the word cause for the word grounds. Suspension, revocation, and cancellation of firearm authorizations. Clause 83, suspension of firearm authorization. Your committee agrees to amend subclause 83.1 to read, by notice in accordance with the subsection 2, the board may in its own motion, or on a complaint made by any person, suspend for such reasonable period as the board considers appropriate, but which in any event shall not exceed 3 months, any firearm authorization granted by the board under this part, if the board determines that the suspension is necessary. A, for public safety. B, as a result of complaint made in respect of whether the holder is fit to be entrusted with a firearm or ammunition, or C, for any other cause. Your committee also agrees to amend subclause 83.2A to read, in the form prescribed stating that the authorization is suspended and requiring the holder to surrender the authorization and all firearms and ammunition to which the authorization relates to the authority no later than 3 days after the date of service of the notice. Your committee agrees to amend subclause 83.3 by substitute the word shall for the word may. We also agree to amend subclause 83.4 by substitute the word review panel for the word minister. We agree further to delete subclause 83.5. Revocation of firearm authorization by the board. Clause 84. Your committee agrees to amend subclause 84.1A by substituting the words firearm authorization for the words license, certificate, or permit. We also agree to insert new subclause 81B, Roman numeral 5, to read dangerous drugs, such a sentence of imprisonment for a term of 2 or more years was imposed. Amid the subsequent and the subsequent subclause amended accordingly. Your committee accept the proposal to add the period of 5 years from conviction agreed on June 22, 22. This was in brackets. Ms. Grant, your committee accept.
Sorry, Chairman, just in the last line relating to the amendment to that was previously read concerning 84.1B5,
Right.
where subsequent subclause amended accordingly.
Okay.
They renumbered accordingly.
Okay, all right. I agree to amend subclause 84.1D by inserting after the words violence, the words or is a person against whom a protection order under the Domestic Violence Act has been issued within the period of 5 years immediately preceding date on which the order comes to attention of the board. We debated this same period, you know, with what's happening around us, so I wonder if 5 years is not too short. Won't disturb you, Mr. Grant, but seriously. Your committee also agrees to amend inserting a new subclause 84.2D by substituting the words firearm and authorization for the words license, certificate, or permit. Your committee also agreed to amend subclause 84.3A by inserting the words and giving the reasons therefore after the word revoked. We agreed to amend the subclause 84.4 by inserting the words without reasonable cause, reasonable excuse after the word who. We agree further to amend the subclause 84.5 by substituting the word review panel for the word minister. Clause 85, circumstances in which firearm authorization becomes void or may be cancelled. Your committee notes the editorial amendment in the marginal note of clause 85 to now read circumstances in which firearm authorization becomes void or may be cancelled. Your committee agrees that the grant of firearm authorization in contravention of the Act would be addressed by the addressed in the schedule. Can I read them? Appeals.
Part 6, appeals. Clause 86, appeal to review panel, 5th schedule. Your committee notes the editorial amendment in the marginal note of clause 86 to now read, appeal to review panel, 5th schedule. We agree to insert a new subclause 86.1 to read, an appeal may be made to the review panel within the prescribed time and in the prescribed manner by a person aggrieved by a decision of the board. We also agree to amend clause 86.1A to read, granting or refusing to grant a firearm authorization other than a firearm manufacturer's license to insert the word or at the end of subclause 86.1C and to delete the word or at the end of subclause 86.1D. We further agree to delete subclause 86.1E. We agree to relocate the 5th schedule to clause 86 and insert a new subclause 86.2, which now reads, the provisions of the 5th schedule shall have effect in relation to the constitution of the review panel. Clause 87, review panel. Your committee notes the editorial amendment in the marginal note of clause 87 to now read review panel. We agree to amend subclause 87.1 to read, upon an appeal under section 86, the review panel shall, after hearing the parties in the appeal, A, confirm the decision of the board and issue such directions as the review panel considers fit to give thereto. B, refer the matter back to the board for a fresh decision on the matter having regard to such further information to be taken into account or inquiries required to be made in the circumstances or the case. Or C, make such other decision in respect of the matter as a review panel considers fit, and shall in writing within 180 days after the appeal is made, notify the board and the appellant accordingly. We also agree to amend subclause 87.2 to read, the time allowed for giving any notification under subsection 1 may be if the circumstances so warrant. We agree to further delete subclause 87.3 and 4. Clause 88, National Firearms Register. We agree to amend subclause 88.2b by inserting the words providing information before the word assisting. We also agree to amend subclause 88.3d by inserting the words authorized in Jamaica after the word ammunition, and subclause 88.5 by substituting the word firearm for the word firearms. Clause 89, function of registrar. Your committee agrees to amend subclause 89.3d by inserting the words provide information or before the word prepare. We also agree to insert a new subclause 89.5a, which reads, foreign law enforcement agency means any entity or association of entities so prescribed for the purposes of this act, being an entity or association of entities having investigative or prosecutorial functions under the laws of any territory in relation to criminal offenses involving prohibited weapons, firearms, or ammunition. Insert a new subclause 89.5b, which reads, law enforcement agency means a person or agency having investigative or prosecutorial functions under the laws of Jamaica in relation to criminal offenses. Insert a new 89.6, which reads, subject to the provisions of this section, the registrar may, with the approval of the minister, enter into a memorandum of understanding or other agreement or arrangement with a foreign law enforcement agency regarding the exchange of information relevant to the investigation or prosecution of any offense involving any prohibited weapon, firearm, or ammunition. D, insert new subclauses 89.7, 89.8, and 89.9, which read as follows. 7, nothing in subsection 6 authorizes a disclosure by the registrar unless A, the registrar is satisfied that the foreign law enforcement agency is subject to adequate legal restriction on further disclosures, including the provision to the registrar of 1, an undertaking of confidentiality on the part of the foreign law enforcement agency, or 2, an undertaking by the foreign law enforcement agency not to disclose the information provided without the consent of the registrar, or B, the registrar is satisfied that the information requested by the foreign law enforcement agency is required for the purposes of that agency's functions, including the conduct of criminal proceedings to enforce laws administered by that agency.
Just a second, may I interrupt, please, Chair? This time I'm using the right version. There's an error in when you looked at clause 87. The report reads
87?
clause 87.
89.7.
87.2. It was just read wrong.
87?
Yes, sir.
Go back.
The amendment to 87. I know you're moving fast.
Yeah.
You
What's the
can
correction
scroll back
there?
up.
Review
The
panel.
report says the time allowed for giving any notification under subsection 1 may be if the circumstances so warrant. The word extended is missing. And this time I use the right version of the book. You have to scroll back up. Or back
Time
down.
allowed for giving any notification under subsection 1
Yeah,
may be if the circumstances so warrant.
right there. Don't go so far. There it is. The bill says may be extended. That's the proposed amendment has the word extended.
Oh, it is in the bill itself.
So I think this is an error because it wouldn't make sense without that word.
87.
Yeah.
Yeah. So we have that inserted. So we pick up now on 89, clause 89, and we go down to 89.8. Where pursuant to a request for the exchange of information, the registrar, in accordance with this section, supplies information to a requesting foreign law enforcement agency. The information supplied shall be deemed to be lawfully given under this act, and every person liable to be proceeded against on the ground that such information was unauthorized or unlawfully given, or that the person was otherwise acting illegally or improperly for any such reason only, is hereby acquitted, freed, discharged, and indemnified against all persons whatsoever and whomsoever from liability arising from the supply of that information. 9, regulations made under section 106 may make provision in respect to the exchange of information pursuant to this section. Part 8, power of search, seizure, and to obtain information. Clause 90, power to stop and search conveyance. We agree to amend subclause 92C by inserting the words without reasonable excuse and a comma before the word escapes. Clause 91, such search warrants. We agree to amend the Shapiro to subclause 91 to now read, a justice of the peace on being satisfied by information on oath that there is reasonable cause to suspect that an offense under this act has been, is being, or is about to be committed, may grant a search warrant authorizing any constable named therein. We also agree to amend subclause 91B by instituting the word cause, by substituting the word cause for the word grounds. We agree further to substitute the words reasonable cause for the word reason at subclause 92. Clause 92, power to search and seize conveyance on our premises. Your committee agrees to amend subclause 92.1 by substituting the word member for the word officer in the first line and by inserting a comma and the words is about to be used after the words being used in the 5th line. At subclause 92(1)B, we also agree to insert a comma and the words is about to be used after the words being used in the 2nd and 3rd lines. We agree further to the insertion of a new subclause 92(2), which reads, a constable who seizes any item under subsection 1B shall issue to the person appearing to be entitled to possession of the item at the time of the seizure a receipt for the item seized. Clause 93, power of a constable or authorized officer to require production of firearm authorization. Your committee agrees to amend subclause 93(1)A to read, a constable, authorized officer of the authority, or authorized officer of the major organized crime and anti-corruption agency who sees any person carrying any firearm or ammunition in any public place may require that person to produce to the constable or officer, as the case may be, for inspection, A, the firearm or ammunition, as the case may be, and the person's firearm authorization in respect of the firearm and ammunition. And we also agree to the insertion of new subclauses 93(4)A to 93(4)B, which read as follows. 4, where the person is unable to produce the authorization required under subsection 1A or B, but is able to satisfy the constable or authorized officer, as the case may be, as to the person's name, address, and identity, and that the person is in fact the holder of a firearm authorization. A, the constable or authorized officer shall retain the firearm or ammunition, as the case may be, and permit the person to produce the firearm authorization within 24 hours thereafter at such police station as may be specified by the constable at the time when the firearm authorization was required to be produced under subsection 1. And B, if the firearm authorization is produced pursuant to paragraph A, that person shall not be liable to be convicted of an offense under subsection 3. Clause 94, powers of constable in respect of concealed firearm. Your committee agrees to amend subclause 94(1) by deleting the word any in the first line of the chapter. Clause 95, retention of firearms and ammunition. Your committee agrees to amend subclause 95(1) by inserting the words, this act, the words or is detained on reasonable suspicion of having committed an offense under this act, and by substituting the word offense for the word contravention. We also agree to amend subclause 95(2) by inserting the words, shall issue a receipt in prescribed form, I think this should be read, to the person from whom the firearm or ammunition was taken, and after the word offense, and inserting the word reasonably after the word be. Additionally, we agree to amend subclause 95(3)B by substituting the words holder of a firearm authorization in respect for the words lawful owner. Your committee agrees to further amend subclause 95(4) to now read, where an investigation under subsection 2 concludes and no legal proceedings have been instituted against a person in respect of any offense mentioned in subsection 2, the firearms or ammunition, as the case may be, shall within 14 days after the conclusion of the investigation be returned to the person who is proved to be the holder of a firearm authorization therefore, or if no holder is proved, shall be transferred to the authority for disposal in accordance with section 103. Forfeiture of firearms and ammunition. Your committee agrees to amend subclause 96(1) by inserting a comma and the words pursuant to section 95(3)A after the word forfeiture, as well as substituting the numeral 103 for the numeral 102. We also agree to delete subclause 96(4) and subsequently renumber the remaining subclauses accordingly. Part 9, provisions in respect of offenses. Clause 97, fixed penalties. Your committee notes the amendment of the marginal note to read fixed penalties. We agree to insert a new clause 97, and we also agree to the new clause 97 to read as follows. The authority may serve a person with a fixed penalty notice if the authority has reason to believe that the person has committed an offense to which this section applies. 2, the offense to which this section applies are A, an offense under section 77(2), failure to display license as required, or section 78, contravention of terms and conditions of firearm authorization, and B, any other offense prescribed under subsection 10. 3, a fixed penalty notice under this section is a notice in writing in the prescribed form, offering the person on whom it is served the opportunity to discharge any liability to conviction of an offense to which this section applies by payment of a fixed penalty under this section. A person served with a fixed penalty notice shall not be liable to be convicted of an offense to which this section applies, in respect of which A, the person pays a fixed penalty in accordance with this section, and B, requires the requirement in respect of which the offense was committed is complied with before the expiration of 30 days following the date of the fixed penalty notice referred to in subsection 3, or such longer period as may be specified in the notice, or the date on which proceedings are begun, whichever event last occurred. 5, where a person is served with a fixed penalty notice under this section in respect of an offense, proceedings shall not be taken against any person for that offense until the end of 30 days following the date of the notice, or such a longer period as may have been specified therein. 6, in subsections 4 and 5, proceedings means any criminal proceedings in respect of the act or omission constituting the offense concerned, and convicted shall be construed in like manner. 7, payment of a fixed penalty under this section shall be paid to the collector of taxes specified pursuant to subsection 10. And in any proceedings, a certificate that payment of a fixed penalty was or was not made to the collector of taxes by a date specified in the certificate shall, if the certificate purports to be signed by the collector of taxes, be admissible as evidence of the facts stated therein. 8, a notice under subsection 1 shall A, give such particulars of the offense alleged as are necessary for giving reasonable information of the allegation. B, state 1, the period, whether 30 days or a longer period, during which by virtue of subsection 5, proceedings will not be taken for the offense, and 2, the amount of the fixed penalty and the collector of taxes to whom and the address at which it may be paid. And C, require the person in the event that the fixed penalty is not paid within the period specified pursuant to paragraph B to attend before the court having jurisdiction to try the offense to answer the charge on such date as may be specified, being a date not earlier than 10 days after the expiration of the period specified pursuant to paragraph B, and that requirement shall constitute a summons for the entity to attend court to answer the charge if the fixed penalty is not paid within this period specified pursuant to paragraph B. 9, in any proceedings for an offense to which this section applies, no reference shall be made after the conviction of the accused to the giving of any notice under this section or to the payment or non-payment of a fixed penalty thereunder, unless in the course of the proceedings or in some document which is before the court in connection with the proceedings, reference is made by or on behalf of the accused to the giving of such notice, or as the case may be, to such payment or non-payment. 10, the minister may, by order subject to affirmative resolution, make provision as to any matter incidental to the operation of this section, and in particular, any such order may A, prescribe 1, the form of of notice under subsection 1 and the collector of taxes to whom a fixed penalty is payable. 2, the nature of the information to be furnished to the collector of taxes along with any payment. 3, the arrangement for the collector of taxes to furnish to the authority information with regard to any payment pursuant to a notice under this section for the amount of fixed penalty. And 5, without prejudice to any offense mentioned in subsection 3, any other offenses under this act to which this section shall apply. B, make provision for the cancellation or variation of fixed penalty notices. Clause 98, evidence obtained from controlled delivery operations. Your committee notes the amendment of the marginal note to read evidence obtained from controlled delivery operation. We agree to insert a new clause 98, which reads 98.1. In this section, a competent authority means the Commissioner of Police, the Chief of Defense Staff, the Director General of the Major Organized Crime and Anti-Corruption Agency, or the Commissioner of Customs. B, controlled delivery operations means the technique of allowing 1, illicit or suspect consignments of firearms, ammunition, prohibited weapons, and other related materials, or 2, substances substituted for them to pass out of, through, or into Jamaica with the knowledge and under the supervision of a competent authority with a view to identifying persons involved in the commission of any offense under this act. 2, evidence obtained by a competent authority through a controlled delivery operation shall be admissible in evidence in proceedings for an offense under this act. Square bracket. And in any case where in accordance with such an operation, any substance is substituted for an item referred to in subsection 1B1, the substance shall be treated as if it were evidence of the item for which it was substituted. Here, Ms. Grant, the square brackets.
Yes, but I think we were instructed to delete those words so they can be removed.
Okay, very well. So we remove them. We note the subsequent renumbering of the old clause 98 as the new clause 99 accordingly. Clause 99, circumstances that may be regarded in determining fines and sentences. Your committee notes the amendment of the marginal note of the new clause 99, which reads, circumstances that may be regarded in determining fines and sentences. We also agree to insert a new subclause 99.2, which reads, in determining the severity of any sentence of imprisonment in respect of which a minimum sentence is specified for an offense under this act, a court shall have regard to A, whether the offender has been previously convicted of a firearm-related offense, or B, whether the offense for which the offender is convicted is in connection with the commission of an offense under this act. 1, by a person who is under the age of 18 years. 2, in an area declared to be a zone of special operations under the Law Reform Zones of Special Operations, Special Security and Community Development Measures Act. Or 3, in an area in which a declaration of a state of public emergency is in force under the Emergency Powers Act. Clause 100, proceedings in relation to persons under the age of 18 years. Your committee notes there are no proposal for clause 100 and agrees the clause should remain as is. Clause 101, punishment, proof, and records in respect of offenses, 6th schedule. Your committee agrees to insert a new subclause 101.7, but I think this was deleted just now.
Yes, pardon me, sir. So I have in the version that I'm working with while you're reading, deleted that clause and amended it to say what you said about 100. About there being no proposal.
So clause 101 should read now. Your committee notes there are no proposals for clause 101 and agrees the clause should remain as is. Part 10, miscellaneous. Clause 102, obstruction. Your committee agrees to insert a new clause 102, which reads, A person who assaults, obstructs, hinders, or resists, or uses any threatening language to an authorized officer executing any function under this act commits an offense and shall be liable, square brackets, on summary conviction, therefore, before a parish court to a fine not exceeding $1 million or on default of payment of that fine to imprisonment for a term not exceeding 1 year. The square brackets, Ms. Grant, are they removed?
Yes, they are removed.
Yes. We note subsequent renumbering of clause 102 as the new clause 103, clauses 103 to 117. Clause 103, authority may auction or destroy firearms and ammunition. Clause 104, appointment of valuator. Clause 105, confidentiality. The committee notes there are no proposals for renumbered clauses 103 to 105 and agrees that the clauses should remain as is. Clause 106, regulations. Your committee insert new subclauses 106, 1C and D, which read as follows. C, the form of receipt to be given to a firearm authorization holder who makes an arrangement for storage under Section 79. D, the development of a service standard framework for the authority in the determination of applications for firearm authorizations, including the appropriate administrative sanctions for failure to adhere to the standards. Clause 107, amendment of first, second, third, and fifth schedule. Clause 108, minister may exempt person or other entity. Your committee notes there are no proposal for clauses 107 to 108 and agrees that the clauses should remain as is. Clause 109, service of notices. Your committee agrees to amend subclause 109C by substituting the words firearm shooting range license for the comma and the words or of a in the second line. Clause 110, documents. Your committee agrees to amend subclause 110.3 by substituting the numeral 105 for the numeral 104 in the first line. Clause 111, service on or delivery to the authority. Clause 112, exemptions. Clause 113, review of the act. Clause 114, repeal of Firearms Act 1967, transitional provision. Clause 115, savings. Clause 116, act not to affect mutual assistance. Clause 117, amendment of other enactments. Your committee notes here, there are no proposal for clauses 111 to 117 and agrees that the clauses should remain as is. Yes.
Okay. Now we take the schedules. First schedule, offenses in relation to which possession of a firearm constitutes an offense under Section 14.3. Your committee notes the editorial amendment on the section under the first schedule by substituting the numeral 107 for the numeral 106. They agree to amend the first schedule as follows. Any offense under Section 10 of the Child Care and Protection Act, sale or trafficking of children. 3, an offense under any of the following section of the Dangerous Drug Act. A, 3, import and export of raw plum and coca leaves. B, 5, cultivation of opium or coca leaves. 6, export or import of prepared opium. C, 7, manufacture, selling, using, etc. prepared opium. D, 7A, export or import ganja. E, 7B, cultivation, selling or dealing in or transporting ganja. Or F, 8A, cultivating, selling or dealing in transporting cocaine. 4, an offense under any of the following section of the Larceny Act. A5, simple larceny. B6, larceny of cattle. C7, killing animals with intent to steal. D, 13, predatory larceny. E, 17, larceny of postal articles. F, 18, larceny in dwelling houses. G, 19, larceny from the person. H, larceny from ships, docks, etc. I, 38, sacrilege. J, 39, burglary. K, 40, housebreaking and committing felony. L, 41, housebreaking with intent to commit felony. M, 42.2, being found by night with certain implements of housebreaking. N, 42.3, being found by night, disguised, etc., with intent to commit felony. Or O, 42.4, being found by night in any building with intent to commit a felony. First schedule, offense in relation to which possession of a firearm constitutes an offense under section 14.3, continued. 5, an offense under any of the following section of the law: Reform, Fraudulent Transactions, Special Provision Act. A, 3, obtaining property by false pretense, etc. B, 5, using premises for commission of offense. C, threatening or intimidating person involved in criminal investigation or trial of an offense. D, 8, offenses relating to theft, forgery, etc. of access device. E, 10, making, repairing, buying, etc. things for copying data from an access device or forging or falsifying access device. F, 11, obtaining a benefit by menace. Or G, 12, conspiring, etc. 6, an offense under any of the following section of the Malicious Injuries to Property Act. A, 2, setting fire to church, etc. B, setting fire to dwelling house or person therein. C, 4, setting fire to house, outhouse, etc. D, 5, setting fire to building belongings to railway, port, or harbor. E, setting fire to building of public character. F7, setting fire to things in or on the building. G8, setting fire to other buildings. H9, attempted to set fire to building or to thing or against, in or against a building. I10, destroying or damaging house or person therein by explosion, by explosion. 114 of gunpowder. J11, attempting to destroy building by explosion of gunpowder. K12, demolishing a building by rioters. L13, injury to building by rioters. M15, injuries to manufacturers, etc. And N16, injuries to machinery, etc. O26, injuries to bridges, etc. P27, placing wood on railway to obstruct engines, etc. Q28, obstructing carriage on railway, etc. R29, destroying electric telegraph, etc. Or S36, placing gunpowder near ship and interest to damage, etc. I find this language interesting, colleagues. Injuries to bridge. 7, an offense under any of the following sections of the Offenses Against the Person Act. A, 22, unlawful wounding. B, 23, attempting to choke, etc. in order to commit indictable offense. C, 24, administering drug with intent to commit indictable offense. D, 31, placing wood on railway, etc. with intent to endanger safety of passengers. E, 36, assault with intent to commit felony or unconstable, etc. F, 43, common and aggravated assaults. Or G, 69, child stealing. 9, an offense under any of the following section of the Sexual Offences Act. A3, rape. B, 4, grievous sexual assault. C, marital rape. D, 13, indecent assault. E, 15, abduction of child under 16. F, 17, forcible abduction. G, 19A, procuring sexual intercourse, etc., by threats or intimidation. H, 20, abduction of child with intent to have sexual intercourse. Or I, 21, unlawful detention with intent to have sexual intercourse. 10, any offense under Section 7, participation in activity of terrorist group. 8, facilitating terrorist activity. 9, commission of offense for terrorist group. 10, instructing commission of offense for terrorist group. Or 11, instructing to carry out terrorist activity of the Terrorism Prevention Act. 11, any offense under Section 4, trafficking in persons. Or 15, threatening, obstructing, etc., concept of the Trafficking in Persons Prevention, Suppression, and Punishment Act. Second schedule, Constitution of the Authority. Your committee note the editorial amendment to the sections under the second schedule by substituting the numeral 107 for the numeral 106. Third schedule, Section 21 and 106, Board of the Authority. Your committee agrees to amend the subparagraph 1, 2, Constitution of the Board by inserting a comma in the words, such that the involvement or association could reasonably be expected to create a conflict of interest or perception that is a conflict of interest after the numeral 76. Your committee notes the editorial amendment to the marginal note of paragraph 2 by substituting the word from the word for. We amend paragraph 2C by substituting the words a firearm shooting range, a firearm dealership, a facility providing training in firearms, a gunsmith business, a private security organization, or any other business in connection with which a firearm authorization is granted or permitted, for the words the conduct of their business. Revocation of appointment. Your committee agrees to delete subparagraph 12.2. Proceedings of the board. Your committee agrees to delete subparagraph 13.4. We note the subsequent renumbering of remaining subparagraphs. We also agree to insert new subparagraph 13.7 to read, where the board makes a decision concerning any firearm authorization, and a reconsideration of that decision by the board may only be made with the participation of the members present and voting as were present and voting on the original decision. So we agree further to insert new subparagraph 13.8 to read, member of the board who knowingly participate in any decision made in contravention of subparagraph 7 commits an offense and shall be liable upon conviction before 2. And to insert the word subject to subparagraph 7 before the word validity and the new subparagraph 10. This 2 square brackets here are empty. Can I be advised? Yes. Left out something, Ms. McCarthy?
Sir, the version that we're seeing now is a previous one.
What's that?
Say that again, sir. Which section you're reading? 13.8?
I'm reading proceedings of the board, and you have in yellow the third paragraph. We agree further to insert new subparagraph 13.8 to read, a member of the board who knowingly participates in any decision made in contravention of subparagraph 7 commits an offense and shall be liable upon conviction before 2 empty square brackets.
The correct thing is now there, Minister. It's displayed on the screen.
What's that?
The penalty provision is now included. It's on the screen.
On the screen?
Yes.
Okay. Yes, before parish code to a fine. Yes, we did discuss this at length actually. Not exceeding $3 million and to insert the word subject to subparagraph 7 before the word validity on the new subparagraph 10. All right, the fine is there. parish court $3 million. Yes, there was some discussion on this one. We settled fine. Now the fourth schedule, Section 79, list of facilities for temporary storage or custody of firearm or ammunition. We agreed to amend subparagraph 2D by deleting the words Office of the Firearm Licensing Authority and substituting therefore the word place. Fifth schedule, constitution of the review panel. Your committee knows editorial amendments to the section under the fifth schedule by the substituting the numeral 86 for the numeral 87, the numeral 107 for the numeral 106. We agreed to amend the subparagraph 1B by inserting the word and after the word Supreme Court at the end. We also agreed to amend subparagraph 2C by substituting the words a firearm shooting range, a firearm dealership, a facility providing training in firearms, a gunsmith license, a gunsmith business, a private security organization, or any other business in connection with which firearm authorization is granted or required for the words conduct of their business. We agree further to amend subparagraph 8 to read, there shall be paid to the members of the review panel such remuneration by way of salary, honorarium, or otherwise as the minister with responsibility for finance may determine. Fifth schedule, continued. Your committee agreed to amend the chapeau of subparagraph 10 by deleting the numeral 1. We also agreed to amend the subparagraph 10D by substituting the word review panel for the word authority. We also agreed to delete subclause 10.2. We also agreed to amend subparagraph 12 by inserting the words and every change therein after the word constituted. We've agreed further to amend subparagraph 14.2 by inserting the words and shall publish the rules of its proceedings in respect of the hearing of appeals and every change with respect thereto in the Gazette. We agreed to delete subclause 14.4. Sixth schedule, section 101, penalties for certain offenses under this act. Your committee agrees to amend subclause 33.2 and 33.3 by deleting the words shall be sentenced to. We also agree to delete subclause 34 and agree further to amend subclause 36.2 by substituting the word 2 for the word 3 wherever it appears. We agreed to amend subclause 38.2 by deleting the word shall be sentenced to. Your committee agrees to amend subparagraph 1 of subclause 39.2 to read on summary conviction before a parish court imprisoned for a term not exceeding 5 years. We also agreed to amend subparagraph 2 to read on conviction before a circuit court imprisoned for a term of not exceeding 15 years. Your committee agrees to amend subparagraph 1 of subclause 42.2 to read on conviction before a circuit court imprisonment for life. We also agree to delete subparagraph 2. We agree further to amend subparagraph 1 of the subclause 40, section 5 to read on conviction and indictment before a circuit court imprisonment for life. We also agreed to amend subparagraph 1 of subclause 43.2 to read on summary conviction for parish court imprisonment for a term not exceeding 5 years, and subparagraph 2 of subclause 43.2 to read on conviction before parish court imprisonment for a term not exceeding 7 years. Circuit court. Your committee agrees to amend subparagraph 1 of subclause 45.2 to read on summary conviction before a parish court a fine not exceeding $5 million or a term not exceeding 5 years. And subparagraph 2 of subclause 45.2 to read on conviction for a circuit court imprisonment for life. We also agree, six schedule. We also agree to amend subclause 47.2 to read on summary conviction for a parish court a fine not exceeding $3 million, or imprisonment for a term not exceeding 3 years. We agree further to amend subclause 48.2 to read, on summary conviction before a parish court, a fine not exceeding $3 million, or imprisonment for a term not exceeding 3 years. We agree further to amend subclause 49.2 to read, on summary conviction for a parish court, a fine not exceeding $5 million, or imprisonment for a term not exceeding 5 years. Your committee agrees to insert new clause 51 to read, restriction on discharge of firearms, on summary conviction for a parish court, a fine not exceeding $3 million, or the imprisonment of a term not exceeding 3 years. Sixth schedule continue. Your committee agrees further to amend subclause 53.2 to read, on summary conviction before a parish court, a fine not exceeding $5 million. We also agree to amend subclause 75.2 by renumbering the subparagraph A as subparagraph 1 and renumbering subparagraph B as subparagraph 2 and inserting the word "on" before the word "conviction." We agree further to amend subclause 92 to read, on summary conviction before a parish court, a fine not exceeding $5 million, or imprisonment of a term not exceeding 5 years. Your committee agrees to amend subclause 1044, breach of duty of confidentiality to read subclause 1054. Seventh schedule, amendment to other enactments, section 117 is. Your committee notes the editorial amendments to the section by substituting numeral 117 for the numeral 116. We agree to insert the words "other than an offense" under section 1054 of that act, subparagraph B under the Gun Court Act. We also agree to amend subparagraph 3 to read, in section 13, delete all the words appearing before the words "may be forfeited" and the person guilty of such breach, and substitute therefore the words "commits an offense and is liable on conviction before a parish court to a fine not exceeding $1 million, or imprisonment for a term not exceeding 1 year." The holiday. We agree further to insert new provision in the Proceeds of Crime Act to read, in the second schedule, delete item 4 and substitute therefore the following: prohibited weapons, etc., for an offense under Part 2 of the Firearms Prohibition, Restriction, and Regulation Act. We agree to substitute the words $1 million for the word "years" at subparagraph 1A, numeral I, Roman numeral I, 1. Your committee agrees to an editorial amendment by substituting the year 1967 for the year 1976, wherever it appears in the memorandum of objects and reasons. For acknowledgments. Your committee wishes to express sincere gratitude to all those individuals, I may say very sincere gratitude to all those individuals and organizations that made written submissions and oral presentation or participated in the deliberations. Your committee wishes to thank the Jamaica Customs Agency, Jamaica Defense Force, Proactive Jamaicans, Jamaica Rifle Association, Licensed Firearm Holders of Jamaica, Cornwall Bar Association, Mr. John Pierre Dipshan, Mr. Michael Todd, Mr. Canute Boucher, Mr. O'Shane Wright, and Mr. Zach Chen. Special recognition to the staff of the following entities for the technical guidance provided in the committee throughout its deliberations: the Ministry of National Security, the Ministry of Justice, the Jamaica Constabulary Force, the Firearms Licensing Authority, Institute of Forensic Science and Legal Medicine, the Office of the Parliamentary Council, the Attorney General's Chambers, and the Legal Reform Department. Your committee is grateful to the clerk, to the House and her staff for the invaluable assistance and kind courtesies extended during this meeting. Yes, I think Mr. Peter Champagne should be added. Ms. McCarthy is correct. He made a written submission and made an oral presentation. So after Zach Chen, please add Mr. Peter Champagne et al.
Yes, sir. Thank you.
Chairman.
Yes, sir.
In the report, I don't know if I want to put in the acknowledgement, the point I made earlier about the submission of the minority report.
Yeah,
it could be reflected in the
how
report.
to insert that. I would certainly mention it in Parliament, but how do we put it? Do we insert that in the minutes of this report? Or
Excuse me, sir, I will insert same before we send the new version of the report to the members.
it would be inserted in the
In
report.
this report that there'll be a minority report, sir.
Right, okay, so that's.
Okay, that's fine.
Yeah, no, it's in keeping with how we have conducted the committee. It's not, won't take anyone by surprise. Let me see that again, Ms. McClarty, the attendance. I was following, it's on your screen, but I go slowly. 19, I missed, apologize, 1, Ms. Fort, 7.
It will be amended accordingly for today's meeting, sir, but so far that's the attendance up to yesterday.
Ms. Fort, Mr. Beatty, 2, yeah. I only missed 1. 16, 2, yes. Mr. President, shall I ask you the 2 meetings?
1 physical and a virtual meeting, sir.
Okay.
Anila, you sure I missed 2 meetings? My record show me missing 1.
I will double check, Minister.
Right. Hi, DPM. I'm joining you from.
Minister, great to hear your voice.
Yeah.
Always good to have you, even if virtual.
All right.
Help to
Yeah.
set the tone.
Well, I was listening as the reading through was taking place, but I've been here.
I know you'll be somewhere there.
Yes.
Right? Just maybe a lot.
Can you scroll, Ms. McCarthy?
So Williams, yes, you're always here. Right, siblings, the Jackson. A short break, regret. I understand why at the time.
Mr. Chair, MP Williams here. I'm not hearing you. You have
I'm just looking at the numbers.
Okay.
Mr. Samuda, he has gone another direction. So he did the first. Senator Sinclair, yes, we thank you. You missed 2? Thought it was 1. He was always there. And Senator Golden Campbell.
Yeah, I think I missed a boat. I think that seems about right to me. I can check my thing, but it seems about right.
And Senator Scott Motley. Thank you much. We'll have it in the completed written report, Ms. McCarthy.
Yeah. Mr. Chair, MP
Yes,
Williams.
Mr. Williams.
Yes, I was just wondering, but if I might refer you back to the acknowledgements.
Yes.
I was just wondering if I know the JFJ, Jamaicans for Justice, they made written submissions, albeit late, because I think I saw it sometime
very
this
late.
week. Very, very late. I was just wondering if, I stand guided, if they will be included in the acknowledgements, albeit late.
I could not acknowledge that report. It came way down after. I mentioned it yesterday, and I guess, and I've been looking through it if there was anything fundamental that would require to be brought in here. And I think Senator Golding had a look at it as well. I didn't find anything that we needed to move on. In fact, we had debated all the issues there is, but we also found their late submission, which an apology that they were not aware, unacceptable from an organization of that standing. That was advertised on 6 occasions and on the virtual media. And we had, I think, nearly 4 sittings of review of the submissions and oral presentations.
Yeah, I'm guided. I really just asked to ascertain, if there was a basis for the exclusion or whether it was inadvertent, but I'm guided.
Chairman.
But we recognize it in the debate, but I wouldn't include it in this. Yeah,
Very
Mr.
well.
Jackson.
But I was thinking of further to MP Williams's point. Once the committee would have acknowledged or accepted the report for consideration, even though the points raised were never adopted. But the mere examination of the submission in the committee would make for a contribution. Not all contributions are embraced or factored into the decisions of the committee, but are nonetheless made. So my humble opinion is that we would acknowledge it because it was considered before the committee. We never rejected.
No, it wasn't.
I wasn't at yesterday's meeting. Sorry.
No, I just mentioned it was there, but we didn't accept it.
Okay. Then in that case, I withdraw my comments against that background.
Quite frankly, we submitted in a different manner. I might have considered, but it was started by saying they weren't aware, which I found a little bit, a bit offline. I might use
Chairman, may I throw out for your consideration that albeit the proper considerations have been raised and any issue taken, that the report still acknowledge receipt of it, or at least note the receipt of it with annotation that it was received late and either not considered. But you're right, we did give enough notice, and the decision could have been taken. But when groups still go through, take the time to go through to respond to something, I would just throw it for your consideration that the report noted that it was received, albeit out of time, and therefore not considered or whatever. However else, the annotation would accurately reflect how it has been treated.
And it's that always speak your judgment on this matter. Let me complete the comments I made. So one, it was exceedingly late, given that this bill has been, we have had 19/16 of this meeting from March. I would therefore have to consider an individual or a new organization, but this is a major human rights organization. And therefore, if they had an interest, could have indicated sometime. So I find it a little bit, and the way it was done disturbs me. So this committee has been conducted, well, if I use conduct, maybe the chairman has managed this hearing, all members have operated this hearing, I consider in the best parliamentary manner I could think of. There have been strong debate, discussion, hearing of views, even disagreements, but with no contention. That was not only submitted late, but was sent to specific members of the committee designed to create dissonance where there was none. I'm not accepting it.
Chairman, since the minutes will record all of this, I think the point would be made. I would only add that we just stress the importance of timely response to invitations to comment on bills being deliberated upon by joint select committees of the Parliament, because the society itself sometimes criticizes the Parliament for the slow pace at which matters move, without at the same time appreciating that the timely participation of all relevant persons will contribute to timely consideration of the matters.
And I want to emphasize my second point, Minister's report, why I was so strong in not moving with it. I said the committees of Parliament have operated in a manner that I thought was very reflective of good parliamentary manner, even where there's agreements. And anybody who seeks to create dissonance by virtue of your communication, I lose my respect for them. And I know this is being minuted. A number of members of the upper, not all, specific members whose contribution to this has been very mature and very welcome. But I think it was done deliberately by the sending organization to create a level of dissonance. And I find it worrying. And when it comes up in Parliament, I'll mention it so it will recognize, but I will not take it in the meeting on that basis. It was not just sent to Parliament for consideration with an explanation. It was sent to Parliament, to the clerk, and to a couple of members, I think, with specific intention. And I'm happy the members didn't take up on that. but I think it was designed to be create, let me say at this point, dissonance where there was none.
Chairman,
Go ahead, Senator.
I apologize. I'm having bandwidth issues, so I'm keeping my video off. But I just wanted to. I think I understand fully what would have disturbed you in the letter that was read out. But I think as a matter of process, however the document came, the Parliament then forwarded the document via email, which is how we got almost all the submissions to all the members. So at this point, I think Minister Malahu Fort is correct that we have to acknowledge receipt of it because it was given by Parliament in an official email to all of us. We can't deny that. So, but consideration, of course, is a different matter, which I have no difficulty with the position you're taking in that regard.
Chairman, I'd also add that I totally understand the position that you're coming from, but just to say that certainly in respect of the Ministry of Legal and Constitutional Affairs, the JFJ is an important stakeholder in the human rights discussions. And if we have to guide them in their interaction with the Parliament, then I think we will have to guide them and just remind them of the procedure that is proper for submission. Sometimes, we just have to take it at a high level. Even if there is evidence of mischief, I'm not saying there is in this case, that is present. We really want to get to the stage where all the engagements are constructive in spite of the views and where we come from on the issues under the deliberation. And I know that you appreciate that point.
And I am not saying the views matter, the constructive minister, please. Let that clear. And that given what Senator Gold said, we should recognize that the clerk sent it to all of us, but we're not considering it for the reason I'm taking it for consideration. And the point you have made, Minister, it makes it even more serious what has been done. Quite frankly, because if there are other organizations to be viewed as serious thing, to conduct themselves in the manner they did is even more worrying. Therefore, any guidance you wish to give as the Minister of Legal Affairs, we're happy that you do that as a minister, but I'm not taking that on in the committee. I'm I was there at their formation, very much involved and knew how they came about and on what basis they came. I'm not asking them to keep true to their principles, to how they were founded. The way the submission was done was not so. But as it was circulated, I take the point made by Senator Golding that we'll make a note it was submitted, but we could not take the time to submit it. So Ms. McCarthy, please make sure it's noted in the report.
I'm not hearing you, sir.
I said make sure it's noted in the report that submission was made from them, but it was not taken given the time it was sent.
Okay, sir. I see Ms. Grant and Mr.
Yes,
Richards.
I see that now. Mr.
Okay,
Richards, Ms. Grant, Mr. Richard, you yield to the lady? I'd expect.
Most certainly, sir.
Thank you. Just querying, it might be more efficient to proceed with a retabled bill. So I'm wondering if the report should reflect that. That is the recommendation of the committee.
I didn't get that.
And having the list of amendments as the
Okay, I'd be advised on that.
McCarthy, would it be what you would append would be the bill with track changes, or you would just
with the completed changes? Yes, and I'll add a notation that it is the bill. Yes, I will add everything that you're saying now.
Just to say, Chairman, that I support the suggestion of the Chief Parliamentary Counsel because the deliberations were so extensive and the amendments themselves will be. So the recommendation would be in light of the extensive amendments being existing bill, that it would be withdrawn and retabled, showing the proposed amendments. Mind you, the proposals will have to be accepted. The report would have to be accepted because the bill has been tabled in its form, and any amendment, there's a process for dealing with amendments, the clauses being deliberated upon. But I think it's just tidier, yes.
All right, we'll organize the process with your advice and parliamentary advice, Minister, so we do it right, which means accepting the report first, and then what? Withdrawing the bill after, and then tabling the new bill. That'll be the steps.
That advice can be fine-tuned, but
Yes,
the report can indicate
what.
Right.
We make sure I get it right. All right, but it does make a lot of sense. It's extensive. It was a very, extensive discussion, but I consider very, very good deliberation on this bill, which is a far-reaching and big bill, and I think there are a lot of good discussion. Mr. Richards?
Sorry, Minister, just to close off, I know you're anxious for us to finish.
But you want to do the further amendments?
Well, right now, Minister, but quick one though, because I wanted us to just sign off on this. In your opening, you spoke about the consequential amendment to the offense against the persons. So we would not have instructed the CPC, so I'm assuming we need to do that send it across the CPC and also confer with our colleagues from Ministry of Justice to get that proposed amendment in the consequential amendment section.
I don't know if you came on the beginning, Minister.
Yes,
You're aware what he is referring to?
Yes, Chairman, let me just add the other matter. We need to do some tidying up to the provision, provision dealing with the
Criminal Justice
Administration Act in respect of pleas of guilty and the mandatory minimum.
Right.
Yes.
Sorry, Minister, I will have to confer with you on that one. Not quite sure of.
Ask Ms. Wilkins,
okay,
to send over something to you in light of the early discussions on the mandatory minimum and how we could provide, better provide for exceptional cases where right now the trial judge would issue a certificate to the convict for appeal in respect of sentencing, and the Court of Appeal would deal with it in a particular way.
Okay.
That part of it,
okay,
right? It was in the early part of the deliberations.
Okay, all right. And my other comment, Chairman, was in light of the removal of the reverse burden and the early discussions surrounding the possible amendment to clauses 33.4 or 36 or 37, whatever the case might be. We've looked at it and we don't think that we need to go any further. I think it's provided for in the case of the traveler. So we don't think that there needs to be any additional changes to the provision.
So the two primary changes then is to make the amendments to recommend the required change to the Criminal Justice Administration Act as indicated by Minister Ford, and
the offense against the person.
And the offense of persons amendment.
Yes.
To make them more in line with what is happening in the Firearms Act.
And
align them properly.
Chairman and Mr. Richards, I think when you were speaking about the offense against the person act, it was limited to just cases of murder. What about the wounding with intent? It would remain at that minimum, because there is a minimum in relation to wounding and shooting with intent. In the offense against the person, does it remain at the 15?
Yes. That should be aligned with it.
Yes.
Yes, it has to be aligned with what's in the Firearms Act. So if there's any variation there, we have to align them.
No, because I'm hearing Minister Ford saying yes. But yes to what? Minister Ford.
The 15 years remains.
No.
Okay. So you mean if somebody's possession simplicity, they get a minimum of 15 years. But if they move from simplicity, if they move from simplicity to shooting, they remain at 15 years.
No, sorry, Minister Charles. Sorry, Senator Charles. Thank you for raising it. Right. My yes was intended to say that some record needs to be done between the provisions, because the conviction for the possession and conviction for an offense using the firearm is at a higher level than just merely possessing it.
Yes.
Right. So that was my yes. I'm sorry if it confused. Yes.
All right. Thank you, Minister.
Okay, thank you, Minister.
All right. Now, we make all these corrections. So do we approve them on the other minutes? Do we have a short online meeting Tuesday morning, which today is Thursday? What time frame, Ms. McCarthy?
Well, sir, there's a meeting for 10 o'clock on Tuesday for another joint select committee, and I think that there might be I would have to check the membership, but there might be an overlap of the membership with this committee, as well as it might also require members of the technical legal team, AGC, LRD, and OPC to be in that committee.
What is that committee meeting on Tuesday?
Pardon me, sir?
This committee is meeting on Tuesday.
Integrity. It's a joint select committee for the Integrity Commission Act.
Minister Fort, you're a member of that committee.
Chairman, as you know, I'm currently overseas. My schedule may or may not facilitate my participating, but I'm trying to see if I will.
I'm trying to see how I can adjust. We need to get this.
The matter of the Firearms Act is intended to take priority over the matter of the Integrity Commission Act at this time, simply because of the resource and logistics reality that we have. But you do recall that in another place, that was a decision that was taken, that in the event of a conflict of schedule between the two matters, we would give priority to the firearms to enable us to complete the work and then come back to the other matters.
This was the call. That's how we bounced a meeting today.
Right.
My colleague was very happy.
But that was the decision that was taken.
It shouldn't take more than an hour, so we could do 10 o'clock on Tuesday morning, but we'd have enough up to 2 hours to complete this evening. But in terms of
and just to clarify, Chairman, sorry to interrupt. This is not to say that the deliberations in the Joint Select Committee on the Integrity Commissions Act are not important, and it is not saying that high priority is not accorded by the government to the review process. It's just the reality of the resources. Yes.
Yeah, that's no, we understand, and yeah, you're on public media, you need to say that. In any case, I said the Integrity Commission discussion will not be concluded on Tuesday. The intention is to conclude the Firearms Act on Tuesday. So there's some merit besides just that and bringing this to completion. So we'll leave all the space.
But if I may, Chair.
Sure, Mr. Jackson.
Just on that point, I think both could coexist. If the committee is proposing to meet for no more than an hour on Tuesday, it could meet an hour earlier and conclude for the other to proceed, particularly if it's going to be virtual.
Virtually meet at 9 and then have the rest of
finish at 10.
We meet by 10:30, 11. If you have to go like overtime, and they could come in at 11.
So it'd be a win-win. Although I can give notice that I will be absent on Tuesday morning. Some prior commitments.
Minister's giving notice as well. We could start a bit earlier. But it could
Minister, I'm giving notice as well. I will be absent next week, Tuesday.
We should have a quorum. Well, we have Parliament in the afternoon. I'm putting a bit of pressure on the centers to come at 9:30. 9 o'clock, a bit early. Well,
Chairman, please remember that another meeting has been scheduled in the AM next Tuesday.
Yes, but background at 9 o'clock is.
I know the other meeting, but this meeting, this will take precedent over that meeting.
Very well.
All right.
Chair, I have, if I may again, Chair, the question of the mandatory minimum sentence. Minister Fort made mention about some exchanges with Mr. Richards, certificates, etc. Who must be privy to that information? Because as I'm indicating to you earlier on, the opposition on that subject. So
no, man, that was discussed early on that there's out for where you may get an individual case that merit a review of the sentence. The judges usually do the certificate, which allows them to appeal the decision. The minister is looking for easier way to allow for that in such cases.
Essentially, Member Jackson, through you, Chairman, is that the matter is best dealt with by the sentencing judge who would have heard the evidence and is best able to assess the matter. So instead of that layer of having to send it above, and this is not to say that it would abate the right to appeal, but to have it dealt with more conveniently and efficiently at this trial stage.
Minister Ford, just from I'm asking the question now from a layman standpoint.
Yes.
As it is in the bill, once convicted, there's a mandatory minimum sentence. In short, as provisions are. By virtue of what you make mention of, is it that you're indicating that should there be such a mandatory sentence, the certificate will provide for a guaranteed appeal against it?
No. So what we have now in the law is that under the provisions of the Criminal Justice Administration Act, where a sentencing judge is of the view that it would be unjust to impose the mandatory minimum, the judge will set out reasons which would enable the convict to appeal on that matter before the Court of Appeal, and the Court of Appeal is then empowered to hand down an appropriate sentence in the circumstances. So you would recall that when the concerns were raised about the harshest effect of the mandatory minimum, we pointed to these provisions of the Criminal Justice Administration Act as an avenue. The concern that will be addressed would be to have the matter dealt with at the trial level instead of on appeal in that case where exceptional circumstances exist.
In other words, if it's the defense lawyer to make a strong case, that is
you can have a sentence hearing, in other words.
Yeah, right, and they make their case there. So it's making it a little bit easier for them if they seem this, if the circumstances are justified.
Fair on both sides
of the too much easy
scale. It's not about ease. It's not about ease.
No, I'm with you, Minister. No,
yes.
I'm not content. I'm just saying I don't want to make it.
But that too. But certainly. If the law is providing for appropriate exceptional cases, then the next question is where is the best avenue to deal with it? So there are clear principles of law that are involved.
Pardon me, though, Minister. In that provision, that, will there be some set of ingredients that would have to be met?
What amount to exceptional circumstances?
Yes.
Yes, so that, let me just ask Ms. Wilkinson, sorry, through you, Chair. Ms. Wilkins, where are you with that matter in the discussion with the Ministry of National Security, further to our internal discussion on it?
Beg your pardon, Minister. I was speaking with a colleague and I didn't hear what you were saying. I'm sorry. Could you repeat?
The proposal for the amendment to the Criminal Justice Administration Act dealing with the mandatory sentencing of persons where the law provides for a mandatory minimum sentence. Remember you had indicated that you were refining to send over to MNS?
I'll have to
check. All right, check back.
I have to, yes, because I didn't personally handle that matter. But let me, I can check for it.
All right, very well.
Minister of Justice, Minister Jack Mevian, I'd love to see your final proposal too from Justice Minister. You know,
I'd had discussion with Minister Chuck on it.
Hello, Minister. I am philosophically very sympathetic to the point. But, you know, I always remember when you made that point, one of your senior learned colleagues made a case for a particular individual that they thought this would be an injustice to pursue. In fact, the person was actually physically disabled, but he was way offline. He was dealing with one who was the leader of the criminal enterprise. And his view, because of the physical impairment, was that this would have been a horrendous thing to give him a life sentence. And we knew, without any doubt, that he was the maximum leader. So, you know, it is not to say to make it a little bit more straightforward to get the appeal process or make it a little bit more straightforward. But you don't want to create a scene where everybody begins to go for sentencing hearing.
No, Chairman.
The certificate by the judge is a little bit complicated, I agree. But given the case, all we have gone through to create a very rigid system and enforcement for and penalties for this very damaging activity in the society. You know, don't go too far in allowing them to get a
Chairman.
way out of it. The exceptional cases going to be rare, as my grandmother says, hen's teeth.
As hen's teeth, I see.
Okay.
All right. Let us just remember, we pass laws that are fair and laws that apply in principle. It's not about sympathy per se, but it's about appropriate exceptional circumstances.
I don't think Member Jackson really had nobody with teeth in Portmore.
Right.
Right. That's
I look forward to those.
Issue. Yeah. If we're going to have a concert, could we? How much time do you see this consuming? And Senator, will be meeting on Friday, right, Senators? Am I right?
Yes. We have Senate meeting on Friday. This
what
Friday.
Do you see as your timetable on Friday?
Well, we're doing
a virtual meeting right after Senate sits because, you know, remember, at one of the other things of the consider, we're going to have to print this document for Parliament Tuesday evening. And I know we will get cooperation from the printing office despite of, but to do it Tuesday morning for Tuesday afternoon is putting them under serious pressure, although they could do some pre-setting, but it's a...
Chairman, may I just ask?
I'm sorry. I'm saying, Chair, it's difficult to predict the Senate on Friday for a number of reasons. I know Senator Sinclair will agree with me.
That Senate on Friday could be long.
Chairman, what we're doing, we are doing the road traffic regulations. I think that is an amendment to the act.
Yes.
But some depending on how critical it is, and that is a decision that is made at a higher level. It can be that the debate on that can be suspended to another, to say next week. So that is something that you'd have to discuss with the leader.
Chairman?
Yeah, because before you comment, Minister, it should be worthwhile considering, because bear in mind, the Senate will have to meet the following Friday within the zones of special operation, which has to be approved by the Senate. So there'll be a short meeting the following Friday anyway. Minister Fort, you're coming in.
Just
Minister.
To say, so the desired timeline would be when? Just asking.
I'm asking if we could have a meeting Friday right after sitting in the Senate. I'll still do it virtually, hybrid.
And that would be to finalize the report?
Yeah. So that if you finalize all we've said here today, Ms. McCarthy only has tomorrow to get it done and to get across to CPC, etc. But Friday afternoon then would give us time to have the bill printed in the short form and looked at by both the policy and legal teams to make sure what we have is what we have said is what we're getting.
All right, you've put that desired timeline. We can speak after the meeting is concluded.
Right.
On that.
Okay, so Senator Singh, I think you should consider that as a possibility. You know, and we'll do it virtually. So the senators would have been in the parliament anyway, and have been some of most loyal members. So it would be easy to get that together, and I'm sure my members would find enough for a quorum. Member Jackson, Friday is not easier. You could give up a Friday evening from the beach in Portmore.
You know, I will make sacrifice for the national.
Especially when the chairman asks of you.
Especially so, especially so.
And Member Williams is a Kingston man. He's always in this constituency, so it's difficult. Easy to catch him when he's right. So we could have a number of team. And I said we'll do it virtually. So Minister Ford, let's discuss that, see if we can finalize it, because I think it'd be good if we can tidy up the report on Friday afternoon. We'll make it like about 2:30. Senator Sinclair, Senator Golding, so you'd have 4.5 hours of Parliament.
But as I said, Chairman, you'll have that discussion. You'll have that discussion
elsewhere. I agree. No, I'm just saying, you know, this as member of the Senate. So we'll certainly discuss that after, because it seems to be a better timeline than to rush into Tuesday morning. All the time, Monday will be off, and the senators will be all over. So Friday afternoon, we'll look at it and communicate, Ms. McCarthy, by later tonight. But we'll start the work in preparation as required. I know you will.
So, well, just to say, Member Jackson, that the minority report, as you know, would have to be appended to the main report before it is tabled.
Right.
Mr. Richards has his hands raised again.
Mr. Richards?
Minister, it is not my intention to prolong the meeting of the committee. So let me just apologize at the start, but I'm just having discussions with our colleagues from IFSLM. They would have wanted an exception for amending the ballistic signature, and they would have sent us some rationale for why. Now, I would have probably misunderstood exactly what they wanted, so would have instructed the CPC accordingly. But now they're advising me that they would prefer to have an exception under clause 13, which is really the prohibition section, because they say that, let me just read this verbatim, that from time to time they conduct research on firearms that by design do not produce consistent signatures, and it may be necessary that these be altered permanently for better identification in the future. A lot of technical jargon is being used here. For example, polygonal rifle barrel firearms like the Glock pistols carried by the police is known in the field to pose a significant challenge to colleagues across the world and their ability to identify bullets fired through them. And this is really as a result of the manufacturing process, which differs significantly from conventionally made barrels. So they've been actually conducting some research for the most suitable ways to identifying these bullets. Now, in instructing Ms. Grant would have made an amendment to clause 30, but 30, 30, but AFSLM is saying that the amendment should really be an exception at clause 13. So I didn't want to instruct CPC without bringing that to your and the committee's attention. and to see how. So the instruction would have been given in respect of clause 30, but they're saying it really should be in relation to clause 13. 13 is under the prohibition section, which really prohibits any person from doing anything to a firearm which alters the ballistic signature. What the IFSLM wants to be able to do is to, as a matter of research, and it's really only in relation to government-owned firearms, as well as for research purposes, that process not be criminalized specifically for them.
Before Mr. Richards, if my understanding is that all government weapons will get an additional ID once they come to the country.
Right.
Yes.
That's a totally different thing, Minister. This is not the.
No, I know this is ballistic, but
right.
Once
right.
you, but the specific number would still be the ID. If you have to modify it globally, it's not a problem if it's elsewhere. But the ID, that is national.
No, okay. So it's two things. So the amendment that they want to be able to do under 30, that's fine. That's not an issue. Their concern is that because there's a blanket prohibition on altering the ballistic signature of any firearm whatsoever,
right.
They don't want to be captured under that provision.
Okay.
So
they could interfere with the boring and get a new ballistic signature correctly for the government ones.
Right, right.
They're creating a ballistic signature for the government.
That's correct. And there's even specific instances.
Attitude that for IFC be exempt in dealing with government firearms.
It's a little more. I think I just want to bring that to your attention, Minister. I think it's something I've probably discussed with Ms. Grant, because I think at this stage I don't want to do anything that will add another section which is going to create referencing and everything else in relation to the bill. So I'll have to discuss with Ms. Grant what's the best approach. So if there's no disagreement to the proposal from IFSLM, then I will have that discussion with the CPC.
Okay. The earlier we now adjourn, you'll have some extra hour to deal with it. Right. Okay.
Thank you, Minister.
Colleagues, that sounds like it. So we're going to try and work with Senate leadership for Friday afternoon. Ms. McClarty, I know you will have to work 28 hours per day until Friday afternoon if you're to meet that deadline. Ms. McCarthy?
Okay, sir.
We'll have to do a special, I'll get the Minister of Justice to make a special request for justice for my clerical support from Parliament. Okay, Minister?
I'm sure Minister Chuck will be happy to assist in that regard.
We need a plea for justice. Yes. The rest of it does. My poor Ms. McCarthy. All right. Thank you all very much. I think we can adjourn now. Let me thank everybody for this up to now, the continued contribution to this. I look forward to reading your minor report to the Member Jackson. Make sure you get to attach it to that one day. All right.
We'll endeavor to have it available on a timely basis.
Yeah, man. And you simultaneously move for the adjournment.
But maybe it's a bit premature, Chairman. If that? I may. I said it may be a bit premature, but I know I may not be at the next meeting for Tuesday. Well, we're looking for Friday afternoon.
Yeah.
But I just want to place on record my commendation for the manner in which you have conducted the meetings of the committee. But sometimes you're a bit gung-ho.
Stubborn.
But the manner in which you conduct is commendable. I want to just put that on.
Thank you, sir.
And Chairman, I'm so sorry. My feed had cut out for a bit. I don't know if it was said already in relation to Ms. McCarthy and whatever the team is that supports her in the Parliament. I really note a level of efficiency and responsiveness to this committee that I think was extraordinary, and I want to just acknowledge her for that.
So say all of us.
So it's all of us. Really, the entire team supporting this committee has been outstanding. I said, we have another meeting, and I said, hold what, as we were saying today, I just add that one sentence. I think they have carried it through. I've learned a lot myself in carrying this through from both colleagues and the committee. And as I said, it's not a big volume, although big enough at one time, with a lot of difficult, complex work. Yeah, to really thank the team this evening for the support. And Ms. McClarty, who we're putting on this last run, she has been more than tower of strength in the activity. Thank you all. So Mr. Jackson move for the adjournment at this point until we hope Friday afternoon, but we'll communicate with you. We're working toward that. All right. Mr. Jackson, you move for the adjournment. So move. That's it.
Seconded, Mr.
Seconded by Senator Charles Sinclair. Thank you very much. Have a good evening.
Good evening.
I think we have some races to watch tonight. We should get to not much. The girls are running tonight.
Jamaica's Diamond Jubilee, celebrating 60 years of independence. Jamaica Festival Queen, Jamaica Gospel Star, Jamaica Festival Song, Independence Float Parade, Independence Street Dances, Grand Gala, and a whole lot more. Check the press for details and join us for the excitement or watch it live on TV.